Hey, good morning, everyone. Fox 10 investigator Justin Lum here, joined by Special Projects executive producer George Obi. It is day 5 of the Lori Daybell trial, the final chapter here in Arizona, as she represents herself, accused of conspiring to commit murder in the shooting at Brandon Boudreaux's home on October 2nd, 2019. Of course, Brandon Boudreaux, her former relative, her former nephew-in-law, and someone who is identified as a dark spirit by the Daybell inner circle, led by Chad Daybell, the so-called Doomsday Prophet, who is now on death row in Idaho. Thank you all for joining us. Already 383 watching. We're going to chat with you guys for a little bit, for about 15 minutes or so. I'm going to jump on Fox 10 Talks, talk to our anchor Ron Hoon this morning, but, multiple streams going on here at Fox 10 Phoenix from our studios, and then we'll jump back on here and talk until trial starts at 10:30. It's a big day because we could see closing arguments this afternoon, George, and see our last witness in FBI agent Nick Balance. Remember, we had 22 witnesses to call. Doesn't mean they all have to go up. Balance is crucial here, coming off very large, heavy testimony by Ray Hermosillo.
Yeah, probably, two key witnesses in the last 2 days. Obviously, I think Detective Hermosillo, his testimony really kind of piecing together the investigation, the crux of the investigation into this shooting. Obviously, a lot of overlap in the work that he and his department did in Rexburg related to the missing kids, the Tammy Daybell investigation. The jury here obviously not seeing or hearing any of that, not supposed to know about any of that. But today, big day for at least the state as they try and put a bow on this case and then hand it over to Lori. And then the other question mark today will be whether or not Lori has any intention of calling any witnesses. She didn't do that in the last trial here in Arizona a few months ago. So I think everybody's just kind of waiting to see if she has any plans to put up a defense this time. And then, by the end of the day, the jury could have the case in their hands.
Yeah, so not exactly sure. We're probably going to have this start about 15 minutes. Are they going 10:15 or 10:30 today?
I think they wanted everybody there 10:15. Any procedural issues, that's been kind of the MO of Judge Boreski is trying to get any procedural issues handled before court begins. And then, of course, like anything else, you want to get an earlier start in case you have anybody from legal counsel or the jury running behind. I don't know. The jury's been pretty much on time in the last week. I think Lori's legal counsel had some childcare issues they had to take care of yesterday. But again, I think they know that the end is near, so fully expect the courtroom to be packed. Everybody show up on time.
All right, we have obtained, or just about to obtain, the motions filed by Lori Daybell this week as she tried to get recused Judge Jennifer Green. Let me go back to the order just so I can read this. I tweeted this or posted this on X earlier. On Monday, Daybell filed a motion to recuse Jennifer Green, the judge who denied her motion to change her trial judge, beating Judge Justin Boreski, who's on her case. Daybell also requested a hearing for a motion to dismiss abuse of discretion. So, reading this right now, the motion alleges that this division cannot be fair. So the motion will be assigned to the associate presiding criminal judge, That associate is Honorable Kevin Wine for the resolution. So with that said, Kevin Wine reviewed the motions that we're about to get and read, and I think they're about 8 pages or so, or less than 8 pages. But it says the court has reviewed defendant's motion to dismiss abuse of discretion, motion for recusal of Chief Judge Green. That was filed on June 9th. This ruling only addresses these two motions insofar as they seek a change of judge for cause pursuant to Arizona Rule of Criminal Procedure 10.1. We heard about that term the other day, too. To the extent that these motions seek other relief, the assigned trial judge will handle that request. Rule 10.1 covers a change of judge for cause. Rule 10.1b1 provides that a party, quote, may not file a motion after a hearing or trial begins. We know that this trial is underway. A jury was impaneled in the 2022 matter on June 4, 2025. Trial in the 2021 matter, that's the Charles Vallow case, has concluded. These motions, therefore, are untimely. For these reasons, defendant's request to remove Judge Green and Boreski for cause is denied. So another motion denied for Lori Daybell, but this time by a third judge who we don't even know. And that's
Right.
a new judge here who had to take this up.
I guess another, this is more grasping at straws. I've used the analogy, just kind of throwing darts at the wall to see what sticks. I think again, this is par for the course. Whether or not her legal counsel is advising her on ways to, again, to maybe do this before the judgment. If you're an attorney watching this play out, I would imagine you're not surprised by what she's doing. I don't think, again, I don't know, Boreski understands this, this kind of stuff happens. The court system is handling it the way they should. I don't know that this impacts the case at all, the pace of the case. As you mentioned, we've seen a few of these over the last few weeks, and they have ruled on them pretty quickly and then moved on. I was interested yesterday when you talked about the filing, when Judge Boreski ordered her to court. We hadn't seen that up until this point.
Oh, yeah, let's see. We have another order.
I don't know how to play into that, but we weren't sure if she just was refusing to come to court, but the judge had to file a motion in order to kind of direct the jail system to bring her down by any means necessary yesterday. But she showed up, looked fine, spent some time cross-examining witnesses yesterday. So,
yeah, I'm not seeing anything. I mean, I see stuff from Honorable Judge Kevin Wine regarding those cases and the motions. I cannot wait to read the motions. Obviously, she not only had it out for Judge Boreski, who she says was biased against her. Now she's got something going on with Jennifer Green.
Yeah.
This is so interesting. It's.
And then,
I'm texting with Nate, who says they're heading in right now, so I expect a 10:15. See if we get around that mark, 10:15 start time, which would be 10:45 for the stream.
We just looked up. The seal is now up. That's a good indication that we're close. That means the gallery is open. And for those watching, she obviously was convicted in the last trial here in Arizona. The penalty phase for that will begin after this trial concludes. So they'll essentially do both penalty phases at the same time. Then you got to wonder about appeals, any other filings. But we all know, those who have followed this case know, no matter what happens at the end of all of this, she's still headed back to Idaho to spend the rest of her life in prison. So is this just more of a, something for her to do, keep her mind busy? You would think that, if she's filing this many motions, that she would maybe spend some time putting up a defense, calling some sort of witness. But who knows at this point? Maybe she's just prepared for her closing arguments later today, and then hoping for the best in the jury case. I don't know, and we can talk more about this later. I don't know that this case is as solid as her previous cases when it comes to working to get a conviction. I think this case there's more leeway, at least in the minds of the jury, potentially of has the state really connected her to the conspiracy part. But that, that may be the testimony from Balance today. The FBI agent when it comes to text messages and religious beliefs and that kind of stuff. This may be the point where the jury starts to hear some of that connection, because you could argue that up until this point, sure, Alex is the shooter. Alex was in the Jeep outside Brandon's home. Alex had all the guns and all that stuff. But you could argue that the jury hasn't fully seen the true connection between Lori and this conspiracy with her brother to shoot and kill Brandon. So I guess we'll wait and see, but today could be a big day.
Yeah, so the chat is asking about the motions. We're about to get into that after this break, as we have more time after we jump off Fox 10 Talks. So you guys, if you already heard about these motions, what exactly Lori is arguing to Judge, or I guess now Judge Wine, about what's going on with her on her case and why she wants Judge Jennifer Green recused, and her complaints regarding how Bereski has handled this case. And we know that she had this sickness last weekend into early last week. But you guys, if you're here to watch us read those documents, we appreciate that. 900 of you watching. I know you guys are on different streams, and that's okay. Other outlets are getting motions as well. That's what happens. We've requested those documents. We have them. But I will tell you right now, you will be here to watch our panel and our coverage as we have this at the lunch recess, possibly heading into closing arguments. You will want to ask questions to Rich Robertson, Judge Mel McDonald, Rachel Smith, the special prosecutor on the case, and Benjamin Taylor as well. We have had you covered for this whole trial, the last trial. It's been a quick 5 days. We will see, though, what happens. This closing arguments is not a lock, as Lori Daybell could call some witness. We just don't believe she has any witnesses at all.
No, we've thrown out a few names, but then we thought about, like, who could she call to help her sow some doubt in the minds of the jury as to her role in all of this, or lack thereof. Because again, all the key players, at least the ones that are closest to this saga, are either dead or, as we've learned, still under investigation, and that being Melanie. So I don't know. I asked Judge Mel that yesterday in the panel, and everyone kind of agreed that if Melanie has representation, her lawyers would be smart to tell her, just take the fifth, don't talk, especially now, knowing, if she didn't already know before this trial or even before this week, that she was still being investigated in this case. My guess is, even if they wanted to call her and file a motion to do so, to add her late, we wouldn't really hear much from her anyway. So that only leaves a few people, Zulema, which is Zulema Pastenis, which would be Alex's widow, if you will.
Yeah, after a quick marriage.
Yeah, maybe. But I don't know what she would offer. On the surface, you would think, would there be any experts? Anybody who could poke holes in Hermosillo's testimony yesterday, or any of the forensic data, any of the crime, the shooting scene data that was collected. But as we've talked about, a lot of times that is, at least for a defense attorney, those are experts that are on paid retainer. Those are people that they go to in cases like this. Lori doesn't have that luxury, obviously, so who knows? But don't expect to see that. So you wonder, who else would she call and what relevance they would have, at least for the jury to again, sow doubt in their minds. And then, we'll see. I think the jury, we're coming up on let's see, Thursday will be a week since testimony started. So a rather short trial. They've been given quite a bit of information, but again, they could have the case by the end of today.
All right, we're going to jump on Fox 10 Talks. I'm going to jump over there for a little bit. Let's take a quick break. All right, we are back. Fox 10 investigator Justin Lum here. Did a little chat with our guy Ron Hoon, but we are now ready to cover the beginning of the day, expecting Nick Balance to testify soon. We're looking at the state seal right now. It's 10:15 Mountain Time, has not started yet, but we are watching now. Me and George have the motions filed by Lori Daybell on June 9th. That was Monday. I mean, we could show them to you, but they are really hard to read, guys. It's really not very legible because of the handwriting by Lori Daybell, and just handwriting alone. It's not this printed, actual bold text. But first off, you have the motion for recusal of Chief Judge Green. It says, pursuant to Federal Rule 4711 of the United States Federal Rules, the defendant requests that Honorable Green, Chief Judge of Maricopa County Superior Court, immediately recuse herself in any further proceedings of the defendant, Mrs. Lori Daybell. Mrs. Lori Daybell. Mm-hmm. I don't think I've seen the Mrs. Lori Daybell. on Mrs. Lori Daybell, the defendant. This motion based on the following memorandum of points and authorities. So she basically goes into her memo here. Are you guys ready to follow along with this? This is going to be interesting, and in real time looks like they're starting to get underway, but I'm going to read as much as I can. So this rule, this 4711, provides that the defendant motion is requesting that Chief Judge Green of the Maricopa County Superior Court immediately recuse herself from any further proceedings of the defendants. On May 29, 2025, Chief Judge Green violated the defense due process by inefficient notice of hearing. Due process requires that the defendant receive notice of hearings. Judge Green, Judge Justin Boresky, the state, and MCSO failed to notify the defense, which above parties in fact significant time for notification. This deprived the defense because of hearing someone else. This deprived the defense because of the breach in notification. The defendant was deprived her advisory counsel as a whole for guidance, as the defendant advisory counsel was appointed by Judge Justin Boresky, who cannot recall appointing them on December 6, 2024. All right, stay with me now. The defendant was left intentionally prepared by Chief Judge Green. Inappropriate hearing in the matter of disqualification of Judge Justin Boresky. The courtroom was dark and difficult for the defendant, but the defendant did answer questions. Okay, so talking about that hearing where we actually saw Judge Green deny the motion to recuse. Right. It's dark and difficult. That's one of the reasons the courtroom was dark and difficult for the defendant. When Judge Green was making her decision, she blatantly, with disregard, alter the federal law. And some stuff I just cannot read. Yeah, a judge's decision is certainly contrary to clearly established precedent of the state court. If the state court applies a rule that contradicts the governing law under absolutely no impression, rather verbally or in... Yeah, so it goes on to say just a bunch of legal terms, mentions... This rule does not allow the biased prejudice to be allowed to remain as presiding judge. In fact, quoting, and just goes on and on. So I'm going to get to something that I can read, because it's basically stating some case law, some federal law and stuff. Judge Green allowed Justin Boresky to remain on the defendant's case, knowing the multiple errors. So she's saying these errors, judiciary misconduct, I believe that says. A judge must be vigilant and independent in reviewing motions. Judge Green and Judge Boresky failed the judicial process in order to obtain a wrongful conviction. Has violated double jeopardy. And this is just really hard to read, the rest of it. But saying that both judges failed the judicial process. Are you guys following this? Are you following
I'm
this?
trying to
I'm reading
read as
this.
you're going.
I promise I can read.
Yeah.
I can read.
So if for
Do you
those
see
wondering
anything
too, by the
clear?
way, so this is when we get court documents, the PDF form, right? Very common. But when you have something that's handwritten like this in pencil, essentially, it's a photocopy image of what's written in pencil. So the clarity is it deteriorates quite a bit. You're almost losing resolution on the actual print. So there are areas of this that just aren't as legible.
This is how.
I don't know if you can. Let's see. Oh,
The green screen there.
yeah.
This is just a look at what.
Yeah.
All right. That's our defense.
Yeah. So had she typed this out or somebody had typed it out for her, obviously this would be a lot easier. But because you're photocopying what's essentially.
But we get the point of what she's saying.
Yeah.
So that was the most.
Yeah.
True. Okay. Well, what we'll do is. Oh yeah. I'll try to read the rest of this. We'll get back to this in a moment. For now, let's get you caught up on everything else if you're just joining us on the record from last night. Here we go. A familiar face in a complex investigation. Lieutenant Ray Hermosillo with Rexburg Police in Idaho taking the stand against convicted killer Lori Vallow Daybell. His role in her prior murder convictions is a major piece of this bizarre saga. Now as she represents herself in court, accused of trying to have her former nephew-in-law killed, Hermosillo has serious evidence on the alleged shooter, Alex Cox. The jury taking it all in on day 4 of trial. I'm Justin Lum, and we are on the record. A very busy day in court for the so-called Doomsday Mom, Lori Vallow Daybell, especially for the prosecution, bringing in some key witnesses, experts who know this case inside and out. But first, we start with Ryan Pillar, Gilbert police officer, whose testimony has really spanned in segments across 3 days. He finishes strong today after a lengthy cross-exam by Lori Daybell.
Yeah, maybe her lengthiest cross-exam, going over, all sorts of details in his investigation, a lot of objections, obviously, from the state, a lot of sidebars this morning because of,
and not short sidebars either.
No,
multiple sidebars too.
They are, and we talked about it with our panel today. Like, does that resonate with the jury? Do they notice it? Do they see, body language of this? Because, again, Lori's trying to find an avenue to poke a hole in at least Gilbert's investigation and looking for ways to, find a way to convince the jury, look, maybe there was, maybe they missed things in their investigation. Maybe they missed some things at the scene of the day of the shooting that would have, exonerated her at all. Remember, this is a conspiracy charge. They're not accusing her of being the person in the Jeep pulling the trigger. So she spent a lot of time with him, maybe a little overkill, maybe stalling for whatever reason. But again, the jury got a lot from him over the last 2 days.
Yeah, and it's just so interesting that the questions that came out were sort of condescending on the part of Lori Daybell. She does this with police witnesses, questioning how they investigate, how they test, and I get it, she's her own defense attorney, so she's trying to poke holes in their side of the story and how they came to the probable cause that she needed to face charges for this conspiracy to commit murder. But I don't know how the jury sees that, but definitely Ryan Pillar on the stand talking about the Tesla being shot at and the trajectory. He didn't have those specific answers for her that she was looking for, but it's also like those are hard details to come up with when so much is happening at a scene and you don't exactly know where the Tesla is and the Jeep was parked.
Yeah, I thought it was interesting. She questioned them about, would you ordinarily just give the vehicle back right after that? Like, why wouldn't you keep it impounded? Why wouldn't you spend more time on it? Now, I'm guessing had somebody died or been, seriously injured in this shooting, they probably would have kept the vehicle a little bit longer. And
he said that, yeah.
Right. So, kudos to her on that part, because that a jury, may be looking at that and going, yeah, that seems rather quick in an investigation. But, She kind of only touched on it a little bit, moved on. We heard the jury ask a few questions after after his testimony.
We've
but
been wondering when the questions would come. We
Right.
started seeing them today.
Yeah, and so maybe this was their opportunity. I mean, we're day 4 into this. Maybe they started to kind of realize that we can ask questions, or we theorized too. They probably had questions from the very beginning, so there were probably things that they were maybe hesitant to ask. Maybe we'll hear from them, the jury, though, after the case. But I mean, to her credit, that was an opportunity, and I think maybe resonated with a couple of jurors that it did seem rather quick, maybe even rushed in the investigation. But again, nobody was injured, and I don't think if there was a threat to the public, they would have kind of moved the investigation along. But also, as we look at the bigger picture here, had they any idea that this case was involved in a much bigger saga, then I'm sure things would have been.
Yeah, hindsight is 20/20. But let's take a look at that section of cross-exam by Lori Daybell.
So is it not in your protocol to preserve evidence?
It's in our protocol to preserve evidence.
But not in this case?
In this case, I made the decision not to maintain custody of that Tesla.
So without this evidence available, how would my experts be able to test for trajectory?
We couldn't test for trajectory with what we had. If it was here today, it's possible that you guys could test for trajectory with the advancements in technology. Again, not being somebody who is trained or certified in any type of trajectory training, I don't know how that process would even look, but we simply don't have the vehicle today as we're discussing this.
Okay, now Trina K redirected testimony to what needed to be the focus for the jury, and that's why redirect is so important, because we mentioned the trajectory of the shooting and how it's just not clear where the Tesla was exactly when Brandon was shot at, exactly where the Jeep was, and maybe where it's parked, but height, so many different things, angles, why does it necessarily matter? Trina basically says this is a shooting. Brandon is not thinking of where to mark, coordinates for his Tesla. So it's a lot there. Maybe, like you said, Lori's trying to cast out. She's trying to do her best, but shooting is a shooting. And now Ryan Pillar's testimony is finally over. The lead case agent on this story here regarding Brandon Boudreaux, but we had another twist. It was Idaho authorities. It was Ray Hermosillo taking the stand for about 2 hours.
Yeah, I mean, this is the detective who I think was most closely related to at least the Idaho case, but the case overall, because of what they uncovered, but ultimately what they discovered, in June of 2020. So he has been involved in all of the trials in some capacity. He did not testify in the last trial, but he was here. You guys saw him down at the court. Very interested to see him follow this case and how connected he is. And then, of course, we know that he is connected to different cases in this saga, right? There's a lot of overlap in the evidence. And so his testimony, I think, was really crucial to the state's argument here. He had obviously direct knowledge of all of this. We're seeing he explained how when Arizona authorities, Gilbert, contacted him about locating the Jeep, he had the duty of going in and kind of surveying this, townhome development community where Lori, Chad, Alex, and then, of course, Melanie were staying. And he explained his process of locating the homes, staking it out. You saw pictures there, surveillance pictures that he took of Lori going in and out, establishing this was her place of residence in Rexburg at the time. And then again, going into more detail about the search for the Jeep, right? Because we learned that's really where he was contacted by Gilbert police at that time. Hey, we have this woman, Lori Vallow, Alex Cox. We have this Jeep. We're trying to find the Jeep. Can you help us? And then that's part of what he explained at the beginning of his testimony.
We talked about this yesterday. We sort of previewed, foreshadowed Ray Hermosillo coming to take the stand and how much knowledge he has.
Yeah, a
and
lot.
We asked the people watching in our poll, would this cause Lori Daybell to open the door to these prior murder convictions?
Mm-hmm.
The answer is no. And whether she got information or advice from her advisory council, that would be interesting to know. But Ray Hermosillo is one of this small group, small police department in Rexburg, instrumental in really digging into the whereabouts of J.J. Vallow and Tylee Ryan, executing a search warrant, trying to find out what was going on because things weren't making sense, weren't lining up. Lori was lying at the time about where JJ was, saying he was back in Arizona with Melanie Gibb, her best friend. And I think Alex Cox had told authorities, Alex told them that he was with Kay Woodcock in Louisiana. Right. There were multiple stories that didn't make sense. Chad Daybell was there at that, door knock, and Chad Daybell said he didn't know Lori at all. At that point, when they were contacted, he was married. To Lori Daybell and his wife. He had murdered his wife, Tammy Daybell, just a month prior. So Ray has so much context to it, and also walking the fine line and not giving all that away to the jury that's not supposed to know these details about J.J. Vallow, Tylee Ryan, Charles Vallow. I mean, we were just looking at surveillance images of Lori going into this town home. That's just a couple of months after she left Chandler for good, after she had conspired with her brother to shoot and kill Charles Vallow while she was having an affair with Chad Daybell. This, according to what we know from the Idaho trials, was the doorway for her to start her new life without kids, without this old marriage, and to be with this so-called doomsday prophet, as they thought that they were gods ready for the end of the world. Now, with that said, Ray Hermosillo, back to this Jeep, doing surveillance on it, and some, I guess, what people will call suspect things when you don't care about your Jeep being taken by anybody or recovered and seized by police. Let's listen to that exchange with Trina Kay.
Did you attempt to contact Lori Vallow to let her know you took the Jeep?
We did several times that day. We made attempts to go over and knock on the door to let Miss Vallow know that we had her Jeep in case they wondered if it was stolen or impounded. And we were unable at any time to make contact with Miss Vallow, and nobody had called the police department stating their Jeep was missing either.
So you never received a call from Lori Vallow to report her Jeep stolen?
No.
Never got a call from Alex Cox saying the Jeep was stolen?
No.
So nobody cares that the Jeep is gone. And at this time, as we were talking about earlier, is the time frame mid-November, early November, Lori's in Kauai getting married to Chad.
Yeah, and if you're the jury in that box, you're listening to that, look, it's not as damning as other testimony in any of these other cases, but you have to wonder, like, if your vehicle is missing, the first thing you're probably going to look at and go, okay, is there a tow company number? Like, did my car get towed? Maybe it got stolen. I need to contact police. I want to find my Jeep.
There's value to it.
Right.
It's an asset.
And you don't let a couple of days go by and go, yeah, I'm a little bit busy. I'll get to that in a little while. Like, nobody does that. That's not normal. And again, this is an opportunity where if you're there, Lori, sitting at the defense table, like, is that the opportunity to go and make a note? Okay, I need to question him about that. And are you sure I didn't like something, right?
Yeah.
Because to me, that sticks out. That is not normal behavior for anybody to just lose track of a Jeep and not be interested in knowing where it was. Now, like you said, she was in Hawaii getting married. She didn't know right away, obviously. I think that maybe authorities had the Jeep, but at the end of the day, they don't know anything about why she's in Hawaii. That's all evidence in another case. To me, that's the point where those are instances where a good defense attorney would try and downplay or damper some of that testimony for the jury, because you have to know that comes off very weird.
At that point, she had to know that police were looking at her, investigating her. When they take your
without
Jeep,
question, yeah.
And they've reached out to you, they want to talk to you.
Mm-hmm.
And then late November. And it lines up to where they take the Jeep and then they go visit her at her apartment late November. They had just told you that same day that they took the Jeep
right
several times. And it's like the first time they ever met in person, November 26, 2019. The next day is the search warrant. They're long gone. And they return back to, they leave, Idaho again. So it was all very suspicious at the time. We backtracked, though, to October and the surveillance video at the Rexburg storage unit. This is clear-cut investigating by police, what they call good police work. go into the home after executing the search warrant. You find this agreement with a business for a Rexburg storage unit. You go to that storage unit. You know, subpoena or whatnot, search warrant for the surveillance videos, October 1st, October 2nd, October 3rd.
Right.
And what do they see? They see video of Lori and Chad moving what looks to be a back seat, what looks to be a tire, and that's connected to the Jeep Wrangler. That's the suspect vehicle. And then also that's happening the same day of the shooting. And we know that license plate readers capture the Jeep with that license plate with no rear tire.
So, you know, there was a lot made, obviously, kind of these October 1st, 2nd, and 3rd, right? And so if you're the jury, you got to kind of keep notes, keep track of all of this. We know the shooting was, October 2nd, right? So then you have this video, October 2nd. You know from your experience, you can get from Phoenix to Idaho in one day. Like, you know, it's a long trip, but you can do it. You know, this is where taking notes is very important as a juror, obviously. But these 3 days are really crucial to this case. This video was really important because you could call the manager of the storage unit to the stand, have him describe, Lori came in one day, rented it, and then we saw them the day later, you know, coming in and unloading some stuff, blah, blah, blah. But you have the video. The video speaks volumes, even though you look at it and you're like, it doesn't show much other than they're removing a tire in a backseat of a Jeep. But you've already established why removing the back seat and why the tire not being on the back of the Jeep is so important to this case. Why would somebody take the back seat out of a Jeep? Why is the tinting so important? I mean, these are all the elements that have been presented up until this point. And then today you show that video from different angles, by the way. You know, it wasn't just some grainy footage, 500 yards away. And you're like, I can't really tell who that is. Like, it's obvious at that point. You've got a clear look at the vehicle, the license plate. Now, you could argue that the outlines of the individuals is not great. But way better than if you didn't have the video and you just had witness testimony of seeing this vehicle and these people there. I think for the jury, it holds more weight seeing it on camera in that capacity. And then having Trina interview Hermosillo about it and he provides even more detail about what we're seeing and why it's so important to this early October timeframe.
October 3rd, just as important. Alex Cox is back. He takes that tire back out of the storage unit. Takes the back seat out, and we know through the prosecution's argument, it's just for him to have a better shot on October 2nd. Brandon survived. He was not hit, but that was the whole point, according to the prosecution, of moving those pieces from that vehicle. Let's listen to Trina Kay ask Hermosillo about this storage unit.
The previous day, we'd seen Chad Daybell rolling the tire in. Here we see Alex Cox carrying it out.
Correct.
Short and sweet right there. And the bottom line is that this surveillance was being done since early November. But being able to get that storage unit video, crucial. And there's also documentation of Lori opening up that storage unit, registering for it. Yeah. And she was there in September. We know that J.J. Vallow's belongings were there. Tylee Ryan's belongings were there. They were murdered in September. The last time that Tylee Ryan was seen, September 8th, 2019. She's believed to be killed, buried in the ground September 9th. J.J. Vallow, last time he was seen, September 2nd, 2019. Believed to be killed overnight or into the hours of September 23rd, 2019. Both found on the Daybell property, and cell phone data of Alex Cox locating them there, basically Alex Cox's device on that property.
So go back to the tire, for instance. Okay, so, if you're, again, defense attorney, you could make an argument that it's not uncommon for people to remove a tire from a Jeep, and it's not uncommon for them to put the tire back on. What's unusual is that they remove a tire from the back of a Jeep, then drive across 3 states, essentially, and then come back and put the tire back on. You would think you'd want the extra tire on your Jeep in case something happened. But again, that is to me, another glaring example of why Lori representing herself is so bad, because this is another opportunity in cross-examination of Hermosillo where you could kind of dig in that and again downplay what Trina just showed. I mean, you could have kind of buffered that whole tire part of it, and maybe the jury goes, oh, okay, I guess that kind of makes sense, and they don't obsess over that video. But again, just the inexperience of it. Like you said, there's so much more evidence that has not been presented in this case, rightfully so, because of the crossover with the other convictions. But man, I just, this is, if you're ever going back and doing kind of a one-on-one on how not to defend yourself, another prime example about not being able to take a note down and say, in my cross, I'm going to do this, this, this. Maybe there was another reason why she didn't, to cross Hermosillo that we don't know about, but another missed opportunity for Lori there.
There's so much evidence that Hermosillo is able to bring to the table with his testimony. I mean, you see the photos of the rifles found in Alex Cox's garage, the scope, just, heavy-duty firearms that, not everyone has in their garage.
Yeah.
Some people do, but I mean, with the context and the circumstances surrounding this case, the jury's probably looking at this and saying, whoa, now they see the Jeep suspect vehicle in their minds. Now they see Brandon Boudreaux fearing for his life on body camera video, or they, just picture him and what he was saying, and the Tesla, the bullet hole, and all of that. It's clear that he is a gun owner. And the Google searches, the Homer J. Maximus Gmail account for long-range shooting, ballistic charges, trajectory calculators, really like scientific terms for shooting, like in the weeds of it all, firearms, searching for a man shot in Gilbert, maps for Dan's window tinting, the map to the Phelps Road address where Brandon Boudreaux was staying. I mean, it's all there under one Google account. Technology is just crazy how much it captures in this wide net of things. The jury has heard this. Lori Daybell does not have one cross-examined question.
Yeah, well, here's another opportunity. Okay, fine. Establish that Alex loved shooting guns. Okay, so he has weapons. He has lots of ammo. Is it weird that his apartment is empty? Okay, yeah, kind of. But, people keep guns in their garage all the time. It's not illegal to have all these weapons.
And it's not her guns.
It's right. It's not my guns. Alex loved to hunt. Alex
so there's an example.
Right. And if you're a shooter, of course you're going to shoot. You're going to search where to shoot, bullet drop, things like that. Is the timing of it bad because he's doing so close to the shooting attempt, or the shooting at Brandon? Okay, yeah. But again, a good defense attorney argues that it's not uncommon what he did, right? A good defense attorney would say, yeah, most gun owners, they search for gun stuff all the time. They, of course they have multiple weapons and scopes and things like that. We heard about the residue and the DNA and all that stuff that was tested.
Yep. Also found in the Jeep. Yeah.
Right. But if any of these jurors have a short-term memory, they're focused on what they just saw. And you just got 2 hours of damning testimony from a detective in Idaho. You could have very easily, again, like I said, dampened it a little bit with just little questions like that. Like, hey, is it uncommon for gun owners to search about gun ranges? Is it uncommon for gun owners to have their weapons in? It's just, to me, it's textbook defense attorney 101. And I'm sure our panel would agree there that there's an opportunity, even if you don't go anywhere with your questioning, you at least cast some sort of doubt that whatever Alex was doing is not out of the norm, especially for a guy his age in Idaho, right? And anywhere really.
Eastern Idaho.
Yeah, I mean,
from Arizona, who always
well.
had an affinity for guns. But if you're Trina K, you say objection, speculation. Maybe even though Hermosillo is probably an expert on firearms, being that he's in law enforcement. But if Lori would have asked, you conducted a search warrant at my townhome.
Did you find?
You said
weapons?
You found,
Yeah.
clothes or closets that were empty. You found other things. You found this agreement for the rental storage unit. Did you find firearms in my garage? Things like that. There's definitely opportunity. We can't wait to talk to the panel about it. But yeah, very surprised that there was no choice to do cross-exam with him. But also, now I'm not really surprised. It was shock in the moment, but Hermosillo just has so much information. So with that said, we're heading into what's possibly closing arguments tomorrow afternoon. One more very key witness for the prosecution. And then the question, does Lori Daybell have anyone to testify for her on her behalf as far as a witness that she intends to call? I doubt it. We haven't seen one in the last trial, but you never know. This could be the Hail Mary. Is it her testifying on her own behalf? if things go as we foresee them, as far as the pattern is, closing arguments could be tomorrow afternoon. For now, make sure you hit the like button, hit the bell for notifications, and subscribe. See you tomorrow on The Record. Okay. Thanks for watching that episode, guys. And we're just getting ready. You see the state seal. We're going to have our possible last witness of the trial. Possible last witness.
I would not surprise me if there were some last-minute surprises. But yes, last witness, FBI Special Agent Nicholas Balance. As you will hear here in just a few moments, Judge Boreski hears a request by the state to hide Nicholas Balance's face and identity from the camera. So all of his testimony this morning, the camera will be focused on something else in the courtroom. You'll hear him. You'll hear his testimony. You'll even see some of the exhibits on the screen, but we will not see his face because, again, the judge will explain exactly why that is when they go on the record. But just so you're aware, you won't miss anything other than you just won't be able to see him. But, again, last witness for the state. And then who knows what Lori will put up today.
And I did post the motions on X. Again, extremely hard to read.
Yeah.
You guys can try, get a magnifying glass, print it out, do what you want to do. And, maybe, that got denied. But it would have been great to have a hearing for that. Just so we could watch.
Right.
And we could watch with you guys and just have even more.
Well, and let her explain what she wrote.
Exactly.
Present, you ready to bring in the jury?
Judge, just a couple things. One, the first witness is Special Agent Nicholas Balance. We do have a prior ruling on that. I would like to request that the FTR be sealed and any video by the media have him blurred per the prior court order.
So it's ordered directing that this particular witness, in order to not compromise other investigations that he may be involved in, the media is precluded from showing his image. Whether they blur him or just focus on another area of the courtroom is up to them, but they're not to broadcast his face or what he looks like.
And so we would ask that FTR as well be sealed.
I'll order that his portion of the testimony be sealed on the FTR. Anything else?
Just one other thing, Your Honor, outside the presence of the jury. We previously yesterday admitted redacted affidavits. For appellate purposes, I'm just going to ask to admit Exhibit 161, 163, and 168, which are the full actual affidavits, unredacted, just for appellate purposes only.
Numbers again, 161 through 163?
Sorry, 161, 163, and 168.
All right, 161, 163, 168 are admitted for the record. They're not to go back to the jury.
Thank you.
Anything from the defense before we bring the jury in?
Yes, Your Honor. I would also like to include the letter from Tammy Lachik that she's unavailable to testify to be admitted for appellate purposes as well.
What, is it marked?
I thought I had a copy. I will get a copy to you guys.
All right, we can mark it, and once it's marked, we'll take that up.
Okay.
No, that's a different one. Okay, let's bring the jury in. You want to get your witness ready?
Do you have one in your file? I never saw it. You ready? I know I printed it.
Jurors can be seated when they get to their chairs. All right, please be seated. The jury is present. The state can call its next witness.
State call Special Agent Nicholas Balance.
Sir, you're going to come up right here in front of my clerk and she'll swear you in.
Hello. Can you please state spell your first and last name? Would you please introduce yourself to the jury?
Yes, my name is Nicholas Ballance. Last name is spelled Ballance, and I'm a special agent with the Federal Bureau of Investigation.
How long have you worked with the Federal Bureau of Investigations?
Since June of 2016.
What are the different jobs you've held while working there?
So I've served as a special agent as well as a period of time as a supervisory special agent. And currently I'm assigned to the Salt Lake City Division and work out of Boise, Idaho.
Now, prior to becoming a special agent with the FBI, did you have other law enforcement experience?
I did. I served as a deputy U.S. Marshal for 9 years prior to working for the FBI.
Now, as an agent with the FBI, have you been serving as a cast field asset?
Yes. So I'm a member of what's called the Cellular Analysis Survey Team, or CAST for short. And it's a specialty that utilizes cellular records as a part of investigations, trying to determine where a phone was whenever that has any significance to a criminal investigation.
How long have you been doing that?
I've been certified since October of 2019.
Okay. When you were working for the U.S. Marshals, did you do any work with cellular phones there?
I did. I was assigned to locating fugitives for a significant period of time with my career with the Marshal Service. And so I was able to use cell phone records to aid in locating fugitives successfully on several hundred occasions.
Can you tell us the education or training that you have to become a CAST member?
Yeah, so for the FBI with CAST, it starts with an application process where you would express interest in getting into the program. And then there's multiple trainings that you would go through before you're considered certified. It would start with our basic course, which is a 2-day course. During that course, you're looking at cellular theory and discussing the different cellular providers that, the major ones in the United States, and looking at records and putting those records onto a map. If you complete that successfully, you would go to our advanced course. In the advanced course, it's a little bit more in-depth than basic, talking about some of the same topics, but you're also provided practical tests that you have to turn in, and then those tests are graded. At the conclusion of the advanced course, if you complete that successfully, you would go on to our what's called CIRA. It's a 3-day course, or was when I went through it, and it's our critical incident readiness exercise. So as a part of that training, there's no instruction. You're just presented with problems and practical scenarios that you would have to go through, map out records, and reach a conclusion. And it's supposed to simulate like a command post style environment where you're getting information rapidly as a part of the training in a short duration. If you complete that course, you would go to our 4-week certification, and that is extensive classroom lecture that includes radio frequency professors that are teaching about in the field of radio frequency. We also get instruction from the major providers in the United States for the cellular industry, to include their engineers as well as their subpoena compliance personnel. On top of that, we have a practical exercise that's assigned to us that we have to work from beginning to end, that culminates into testifying at the end and presenting a report and being challenged on that report, both by prosecution and defense that are simulated role players. At the conclusion of all of that, you would be considered certified as a member of CAST.
Do you have any annual recertification types of trainings to remain active as a CAST member?
Yes, so we have to complete a certain number of record analysis during that each year. And on top of that, we have a one-week certification conference that we attend each year that includes updates from the major providers in the cellular industry, as well as updates when it comes to the field of cellular technology from radio frequency engineers. And that's each year that you're in the program.
Okay. Have you previously testified as an expert in the area of cellular analysis?
Yes, ma'am, I have.
And as a CAST member?
Yes.
In this case, were you asked by the Gilbert Police Department to analyze some cell phone records?
I was.
Were you provided with cell phone records for a Lori Vallow for a 480, 489, 4652?
Yes, ma'am, I was.
Were you provided with cell phone records for an Alexander Cox for the phone number 480-351-9120?
Yes, ma'am, I was.
And were you provided with track phone records for a cell phone purchased from a Walmart in Idaho Falls, Idaho, with a phone number of 304-960-5998?
For that one, I was from Track Phone as well as from Verizon.
Okay. Were you also asked to include or analyze some Google historical location data associated with a Google account, homerjmaximus@gmail.com?
Yes, ma'am, I was.
Can you tell us what is historical location data?
Yeah, so Google offers a range of services with their products, and one of those being location history. So if you were to opt into location history on your Google account, what that would do is Google would maintain different locations that the device that's reporting that location information where it was historically. So if the user has that active, it would depend on the specific phone that was relaying that information to Google. So as an example, if I have a Google account and I have 3 different phones, I could access that Google account from all 3 of those phones, but if only one of them I've opted into location services, then any of the location history that Google maintained would only be associated with that specific phone for the location of where that phone was.
But the data overall from Google, they might provide information from all the devices, though, in terms of like searches that were done.
Correct. And again, it depends on how the user has their account set up with what information is going to be maintained by Google, specific to the many different products that Google has and offers to a user.
Okay. Were you asked to look at a specific time frame?
I was, specifically late September into early October in this case.
Did you create a report to help explain your process and explain the analysis of these cell phone records and these Google records?
Yes, ma'am, I did.
And because it's on a thumb drive, I'm just going to share the first page to you. And it's 189, if I can have my paralegal. Does that look like your report that you created in response to the request by Gilbert Police Department?
Yes, ma'am, it does.
State will move to admit Exhibit 189.
Any objection to 189? All right, 189 is admitted.
If I may publish. So starting on the first page of your report here, what did you include here for us to understand as part of your analysis and review of devices and phones?
So this is basically the cover sheet that I would put on all my reports, and it's showing the specific accounts that I did analysis for. So in this case, the 3 telephone numbers are listed at the top, one ending 4652, one ending 9120, and one ending 5998. Additionally, in this case, since I analyzed Google location history, the account that Google location history was associated with is listed. That's the homerjmaximus@gmail.com. The specific dates that I conducted analysis for, which in this case were September 25th, 2019 through October 3rd of 2019. The date that I completed my report, case number associated with the report with the FBI, and then my name.
Now, you were provided these records that from the Gilbert Police Department for these cell phone numbers. Did that include information like subscriber information?
It did, yes, ma'am.
So the 480, 489, 4652, when you reviewed those cell phone records from Verizon, did that show a subscriber of Lori Vallow?
So it did not. It was subscribed through TrackPhone. So the name was not Lori Vallow, but there was an email address on the subscriber sheet associated with her.
Okay. The 480, 351, 9120, was that as a Verizon record? Did you receive the Verizon or the TrackPhone records?
I did, and that was subscribed to Alex Cox.
Okay. And the 304, 960, 5998, was that Verizon or TrackPhone?
So it was subscribed through TrackPhone.
When we're talking about TrackPhone and Verizon, and you talked about sort of major companies, how do those all interrelate?
Yeah, so when you're looking at cellular providers, you have two different categories looking at kind of from a wide perspective. You have companies that have infrastructure, like cellular towers that they maintain throughout the region that they provide service to. So Verizon is one of those companies. They have cell phone towers throughout the United States. When you're talking about TrackPhone, they're a mobile virtual network operator, which basically means that they don't have cell phone towers, so they have to lease space with another network in order to provide service to their customers. So TrackPhone, specifically in this instance, was utilizing Verizon for the number ending 5998 to provide service to that customer.
Okay. And the Google records that you were provided for the Homer J. Maximus at gmail.com, did that provide subscriber information?
It did, and that was associated with Alex Cox.
The second page of your report, what is this telling us about in terms of your analysis and explanation?
Yeah, this is basically just explaining the methodology of how I created this report and the process that goes into place in order to take records from a provider like Verizon and then put those records onto a map. Again, this is the methodology of how that would be done.
The third page here, one of the things that stood out was the time. We've heard about universal time. When you are looking at most or all of these cell phone records, were you provided the times in universal time, UTC time?
Yeah, so depending on the provider or the company that's providing records, kind of the biggest difference that you'll see in the different records types is a lot of them will provide records in different time formats. So specific to Google, they provide their records in what's called UTC time. And so that's just a time standard to where if you wanted to do the conversion and see what time that was in the area where you're at, you would have to do a conversion depending on what location you're in order to get it into the local time.
So when you were mapping these cell phone records and these Google location device records, were you converting them for the purpose of your report into the local time, either Arizona or Idaho?
Yes, ma'am, that's correct.
So while we're going through your report, all of those times will reflect either Idaho or Arizona, depending on where we're looking at.
Correct, and the report will reflect those times as well.
What do we see here, and what is this explaining to us?
So just to talk briefly about how cell phones work and kind of how we're utilizing the methodology that I spoke of to map and estimate where a phone was historically. One of the things that we look at is how far a cell phone tower provides coverage to. That's usually one of the major questions. So typically a cell phone tower density map is going to look very similar to a population density map. So here we're looking at the city of Phoenix, and as you can see, there's a couple of towers in downtown Phoenix and in the urban areas of Phoenix. Those towers are going to provide coverage to a much smaller area due to the number of users that are needing to access a particular carrier. As you get more to the rural areas, you can see that those towers are more spread out, and towers in rural areas are going to have a larger coverage area just because there's not as many people in those locations.
Okay. And what is this page 5 reflecting?
This is just an example of what cell towers look like, not to insult anyone's intelligence, but if you look at the second tower from the left, traditionally back in the day, that's what we saw cell phone towers look like. Now there's more of a push to make them more aesthetically pleasing. So as you can see, like with the cactus, that's actually a cell phone tower, trying to disguise it so it's not looking like you have all this different metal around an area.
Page 6, what is this explanation for us in terms of what we've seen for your analysis?
Sure. So whenever I'm mapping a estimated location of where a phone was, I'm looking at a traditional tower has 3 sides. So if you look at the graphic on the left, you're looking at the tower itself, and then there's 3 sets of antenna facing 3 different directions on the tower. So if you look at the graphic on the right, that's looking from the top down. And so the cell tower is pushing out coverage kind of 360 degrees. But what providers do is they put different sets of antenna on that tower in order to optimize their network and divide that coverage up into different sectors. So whenever I'm looking at a call detail record and I'm seeing a particular call that might be of interest to an investigator, 1, 2, and 3, and in my tower list, I'm able to see the tower that was used, and I'm able to see what's called an azimuth, which if you're not familiar with that, it's basically just showing me what the center line of a sector, what direction it is coming from the tower. So if you're looking at this particular graphic on the right, you can't see the 0, but it starts with 0 and goes all the way around to 360 degrees like a compass. So the center line of sector 1, that azimuth would be 0 degrees. Same thing with, if you look at sector 2, the azimuth on sector 2 would be 120 degrees. So that azimuth allows me to estimate the location of where a phone was in relation to where that tower is.
All right, so this information of the tower sectors and the azimuth, was that included with the cell phone records that were provided to you for those 3 phone numbers?
So it's included in a different file, but all of the different cellular providers that have towers throughout the United States, they have what's called a tower list that they update pretty regularly, at least every few months or quarterly. So in conjunction with the call detail records that show me who was called, at what date and time, what tower was used, I can marry that up with the tower list, and then I can have an estimate of where that phone was whenever it had that specific interaction with the network.
So someone like Verizon will provide you with, for that specific phone number, calls made and what tower they're using, and then you're able to then get the location of that tower from Verizon to map it.
Correct. If you think about, and everybody can still do this online, but back in the day when you had your cell phone, each billing cycle, you would get that bill in the mail, and it would be fairly thick because it included all the different calls that were made on that account. And so the call detail records are very similar to that. We can see the date and time. We can see that it was a voice call. We can see the direction, if it's incoming or if it's outgoing. We can see the associated number. But what you don't see on that bill is the tower information. So the call detail records that we obtain as law enforcement, they include those columns, and those columns allow me to know at a specific date and time this tower and sector was used, and then I can marry that up with the tower list and provide that estimated location of where a phone was.
So what do we see here on page 7? We have a legend for us.
Yeah, so this is depicting how I'm going to display different pieces of information on my report. So starting at the top, you're looking at Verizon towers are going to be represented with red dots. That's going to be important because when I talked about before, where you're looking at the density of Phoenix and towers are going to provide coverage to a smaller footprint in an urban area where there's towers close by, it's important to note where other towers are in relation to the one used. Because typically what we see is that a tower provides coverage to the next tower. So that's what allows me to estimate the coverage area of a tower and sector that was used for a particular interaction. Next, we see how we would represent the tower and sector. So the blue, black, and the red are going to be the 3 different phones in this case. So if you look at the blue, that's representative of a tower and then the direction from the tower that that sector is facing. So the blue graphics are going to represent the phone number ending 4652. Black will represent 9120, and red will be representing 5998. Additionally, you see to the right the call information box. So whenever a phone has an interaction, you have that line in a call detail record, just like I talked about on the phone bill. I'm going to represent that particular call with the information that's provided from the carrier here. So you'll see the tower information at the top, the target number that it's associated with, so what record that particular line came from, what account, the date and time, direction of the call, duration of the call, type of the transaction, the word I mentioned earlier, azimuth, which gives us the direction from the tower that that specific interaction took place, and then the associated number. And then additionally to the left, you'll see a call information box where there's data interactions between a phone and a network. There's less information there, but you'll at least see the date and time and the direction from the tower that that sector faces.
Okay. So these are things we will see in the mapping that you did for this case.
Yes, ma'am, that's correct.
Oops, hold on. All right, page 8.
So I just spoke about how I would map cellular records. This is a legend to show how I would map Google location information. So I talked a little bit about Google derives their location information from different data sets. And so Google can estimate a location of a device by locating it via the GPS chip within the phone. It can do it via Wi-Fi as well as cellular. Specific to this case, we're only going to talk about locations that were derived via GPS and Wi-Fi. And so that's the icon that will be representative of that specific location line in the Google return. You also see a margin of error, which is showing Google in each specific line where they locate a device, they provide the estimated margin of error associated with that specific locate. So there will be a circle around the specific locate on the map. And then also, depending on if it's only a few locations, you'll see the information box with the specific date and time. If there are significant number of records on the same map, it would be very difficult to read to put every single information box associated with each line. So you'll see a summary box, which is going to include the number of records that are represented, as well as the margin of error associated with each record and where it was sourced from. I'll also point out here that I know I mentioned it before, but all of the Google location history in this case is going to be reported from the device ending 9120.
All right, so the 9120 number is the phone associated to Alex Cox, or subscribed to Alex Cox.
That's correct.
So whenever we see Wi-Fi or GPS, it's from Alex Cox's cell phone.
Correct.
Now, you talked about a margin of error, and we see on page 8 here the R14. Can you tell us what that means?
Yeah, so if I were to map a latitude and longitude that Google provided onto a map, they also provide the margin of error. So I would place that icon on the map, and then I would look at the margin of error column. So it's represented by R and then a number, and that 14 there, that means 14-meter radius from that mark on the map. The radius would be 14 meters, and then draw the circle around at that 14-meter radius. That's the margin of error that they're reporting.
So does that mean if you are told that the phone is at this GPS location, and there's a margin of error of 3 meters, that the phone could be anywhere within a 3-meter diameter of the spot?
Yes, and that's how Google's reporting it, so that's how we're mapping it.
Okay, and so when we see the circle that's shaded, is that your depiction of the margin of error that was provided by TracFone or by Verizon?
So that's the margin of error provided by Google.
Google, sorry. All right. And so again, we will see those icons and those circles for the margin of error for the Google records on your mapping.
Yes, that's correct.
What do we see here in this legend?
So these were addresses that the investigative team provided to me that were of significance to this investigation. And so it's got the address associated with each one, but when I represent them on the map, it's going to be utilizing the icons to the left.
So you had Brandon Boudreaux's address, 3875 East Phelps Street in Gilbert, Arizona, as one of the places for you to have a point of interest?
Yes, ma'am, correct.
And then 2 different units at 565 Pioneer Road, apartment 175 and apartment 107?
Yes, ma'am, that's correct.
And then a self-storage plus on Airport Road in Rexburg, Idaho?
Yes, ma'am, correct.
And then a Walmart at Idaho Falls, Idaho?
Yes, ma'am.
And then also a Melanie Boudreaux residence in Gilbert, Arizona?
Yes, ma'am.
So first map, can you tell us what we're seeing here and explain everything?
Yeah, so these maps are just laying out where the locations of interest were that was provided by the investigative team. And so whenever I have this is zoomed out a decent ways to incorporate both the address down in Idaho Falls and the addresses that are in Rexburg. And so there's a box to the side that's basically showing a zoomed in view of the apartment complex that includes the addresses for Alex Cox and Lori Vallow's apartments.
All right, so the Idaho Falls WM at the bottom is that Walmart, and then we can see the storage unit and then the zoomed out of the 2 apartments in Rexburg, Idaho.
Yes, ma'am, that's correct.
Is this just a closer up single page of that?
Yes, ma'am, it is.
All right, what do we see here on page 12?
So the previous 2 pages were up in Idaho. This is down in the area of Gilbert, Arizona. So this includes 2 addresses, one for Brandon Boudreaux and one for Melanie Boudreaux.
Okay, and so we see that with the bluish purple and the pinky color?
Yes, and I didn't mention before, but you can see the red dots. Those are representative of Verizon towers that are in the area as well.
Okay. So when we get to page 13, you had told us that you were provided with the homerjmaximus@gmail.com records that were obtained by law enforcement. Did those homerjmaximus@gmail.com Google records show that the records were tied to an MEID number?
Yes, so that's a mobile equipment identifier. In the case of Google, this is very similar to what's called an IMEI, or International Mobile Equipment Identifier. The IMEI is the equivalent, kind of like a VIN on a phone. So it's associated with the hardware itself of the cell phone.
And so why is that important to see that the Google records for the Homer J. Maximus is tied to this MEID number?
So anytime, I think I mentioned it before, but anytime a phone accesses a Google account, Google keeps a record of that. And one of the things that they record is that MEID number, which, like I said, in this case is synonymous with the IMEI, or the hardware of a phone. So that identifies a device. So what I can do with that number is I can then take that to different cellular providers and determine whether that number has ever shown up on their network and whether they can associate that number to an actual telephone number.
And was that MEID number that we see here on page 13 that is associated with Alex Cox's Google records associated with that cell phone number 304-960-5998?
It was.
And did you determine, or were you able to review records to see when that association occurred?
Yeah, so if you go to the next page of the report, that's going to be a record that we received from Verizon, and it shows that the, again, IMEI is associated with the 304-960-5998, and they list an effective date of September 27th, 2019.
And just going back at the bottom of this information, we saw a registration time and a first data connection time. What is that?
So that's showing when that device accessed the Google account for the first time. And we see also the September 26th 2019 at 7:58, which would be again in UTC time. So to get to either Idaho or Arizona, you would have to subtract 6 to 7 hours to get to the time of where that occurred.
So to be clear that we understand, what we're seeing now is that the homerjmaximus@gmail.com records from Google, the Wi-Fi and the GPS data are always going to reflect that 480-351 number, correct?
Yes, ma'am, correct.
But is data in the Google records that now has been associated to that 304-960-5998.
Yes, and as I mentioned earlier, you can have multiple phones that access your Google account, but unless you have location history turned on every single one of those phones, Google is not going to record the location history associated with those phones. It's only going to record it on the device that you specifically turn that location history on.
So when we get to page 15 here, what are we seeing in these records?
So whenever you have a phone that is, like in this instance, purchased through TracFone, but utilizing the Verizon network, there's two different places that law enforcement has to go to get the complete set of records. So we would have to go to Verizon in order to see the call detail records and what towers are being utilized by that phone. But the point of purchase and subscriber information, we would need to go to TracFone. So specifically, this is the point of purchase information from TracFone associated with the number ending 5958.
So this tells us that this 5958 TracFone was purchased at a Walmart at Idaho Falls, Idaho?
Yes, correct.
And when does it show that being purchased?
So it shows it being purchased on September the 25th, 2019 at approximately 7:10 p.m.
Okay. And does it show a store number of 5494?
Yes, ma'am, it does.
So when we get to page 16, we start to see those icons for the Wi-Fi. So we're now talking about the 9120 number?
Yes, and so being this is the first map, I'll explain it a little bit more thoroughly than the others. But as you can see at the top, you're going to see what this record represents, Google location history associated with the homerjmaximus@gmail.com account. And then basically, I'm putting the bookends of the times at the top. So these records are from September 25th, 2019, starting at 7:07 p.m. and continuing through 7:16 p.m. There's 6 of them, so you see a summary box. They're all sourced or derived from Wi-Fi, and of the 6, the margin of error is between 16 and 100 meters, which you can see with the black circles. Obviously, the smaller one there in the middle is closer to the 16 meters, whereas the larger ones are at 100 meters margin of error. And they are consistent with the device 9120 reporting its location to Google as being at the Walmart on Utah Avenue in Idaho Falls during that time period.
So basically, the 9120 cell phone is reading Wi-Fi signals around it and reporting that margin of error to Google.
Yes, and one thing I didn't explain earlier is that whenever a location is derived from Wi-Fi, it doesn't mean the device was connected to specific Wi-Fi points. It just needed to be in range of those Wi-Fi points and see it. So if you've ever experienced where you're going through the airport or you're looking at your location on Google Maps and it says turn on Wi-Fi to get a more accurate or precise location, it's because Google has a pretty vast database of knowing where Wi-Fi access points are throughout the United States. And so if I'm sitting here and I'm close to a McDonald's that has a Wi-Fi hotspot on it, and my phone sees that Wi-Fi hotspot, I don't need to connect to it for Google to know that that specific Wi-Fi hotspot is located at a specific address. And then Google can estimate my location based on my phone seeing those different Wi-Fi access points.
So in this case, we see the phone that's subscribed to Alex Cox, that's using his Google account, is at this Walmart in Idaho Falls between 7:07 p.m. and 7:16 p.m.?
Correct. I would say it's consistent with being at that Walmart.
And so we had seen in the prior slide that the track phone, the 304-960-5958 number, was purchased around 7:10 p.m.
Yes, ma'am, that's correct.
So this phone associated to Alex Cox is utilizing or is reading the Wi-Fi around it and providing this data around the same time when that track phone, the 304 number, is being purchased at that Walmart.
Yes, ma'am, correct.
What does this next map show us, page 17?
So again, I'll speak a little bit more thoroughly on this one since it's the first time I'm showing a tower and sector being represented on my report. So again, at the top, you see the tower interactions, and the number associated with it is going to be the number ending 4652. The date, again, I'll usually book into this unless everything occurs within that same minute, but we're looking at September the 25th, 2019 at 7:08 p.m. And we see 2 incoming calls that occur, and 4652 is utilizing a tower and sector that is in close proximity to that same Walmart on Utah Avenue.
Now, when we are looking at this cell tower usage, do you know whether or not that phone has to be within that azimuth?
Sure. So whenever you're talking about radio frequency propagation and what the footprint of a tower's coverage area looks like, it's definitely not best represented by lines in the sand. It's more representative of like a cloud, to where if you look at the lights in this courtroom, you have the light that's shining up in the corner there, and you can see it pretty bright on the wall. But as you get farther down the wall, that light starts to dissipate and starts to get more and more dim. There's not just a line up there on the wall where the light ends. Radio frequency can be looked at the same way. So that signal is going to dissipate as it gets farther and farther away from the area where it's meant to provide coverage to. And so when you're looking at how I'm depicting this on a map, I'm showing the sector based on the azimuth and both sides of what the endpoints of that sector look like. But I would expect to see a phone that is in close proximity to that line potentially still be on a sector, even if it's not within that parameter. All that to say that when I look at this particular graphic, based on my training and experience, I would say that tower and sector is consistent with providing coverage to that Walmart due to the close proximity.
So what we can say is that the 4652 number associated to Lori Vallow is utilizing a tower in the area of the Walmart within a couple minutes of that track phone, the 304 number, being purchased at that Walmart.
Correct, 2 minutes prior.
And in fact, does one of her phone calls last about 10 minutes?
Yes, ma'am, correct.
So through the time of that purchase even.
Yes, ma'am. I would just point out that whenever, if you go back, sorry, to that page, whenever I'm looking at a tower interaction, whenever that phone is interacting with the network, we're looking at whenever that phone initiates that specific interaction. And so during that 10 minutes of time, I can't tell you specific to Verizon where that phone was located. I can only tell you at 7:08 and 31 seconds, it was utilizing that tower and sector. But let's say, for instance, that phone were to move out of the area, that would not be able to be determined by the records that I have.
That phone number that is being called at that time as well, are you familiar with that phone number?
I am, yes, ma'am.
The 480-266-8587. Whose phone number is that associated to?
I had that associated with Melanie Boudreaux.
So at the time that Alex Cox's phone is in the Walmart, at the time that that track phone is being purchased, Lori Vallow is speaking with Melanie Boudreaux using a cell tower in the area of that Walmart as well.
I wouldn't be able to say who was speaking with who. I could only say that the phone number 4652 received an incoming call from 8587, and then who those numbers are associated with.
So at the time that the phone associated to Lori Vallow is using a cell tower in the area of the Walmart, she is receiving a call from the phone associated to Melanie Boudreaux.
Yes, ma'am.
And that's September 25th.
Yes, ma'am, correct.
What do we see then when we get to page 18 here?
This is looking at the first mappable record for the number ending 5998 on September the 26th at approximately 11:31 p.m., making an outbound call utilizing a tower and sector that provides coverage to both Lori and Alex's residences.
All right, so this is the phone that was purchased at the Walmart that we were just discussing in the prior maps.
Yes, ma'am, correct.
So on the 25th, that phone is purchased from the Walmart, where we see cell phones associated to Alex Cox and Lori Vallow being there or near there at the time of the purchase. And now we see the phone being activated.
So I wouldn't be able to say specific to whether that's the actual activation, but that is a call, I believe, to a number associated with either Verizon or TracFone, but
We do know from the prior records that the phone was activated on the 26th, though.
correct. I know from records, and I don't know if it was one that we showed in here, but I know that it's first started being used on the 26th.
And I think if we were looking at page 13, we showed the first data connection time was September 26th at 7:58 p.m. UTC.
Correct. That was when it connected to Google, if I'm recalling correctly. And so the phone wouldn't necessarily have to have Verizon service to connect to Google. It could have done that via Wi-Fi or some other method to connect to Google the first time.
So what we're seeing here then is something potentially different, where we now know this phone, the 304, is actually using cell towers and able to now make outgoing calls.
Correct.
And it's using a tower that would be consistent with covering the apartments for Lori Vallow and Alex Cox.
Yes, ma'am.
All right, what do we see here? We're still on September 26th and
Yeah.
around the 2 minutes from the previous map.
Yeah, so this is just a record in close proximity in time, showing a Google location record where the number ending 9120 was reporting its location to Google as consistent with being at Alex Cox's apartment. That's on September the 26th, 2019 at 11:33 p.m.
So we see the track phone from Walmart using a cell tower at 11:31, and then we see Alex Cox's cell phone, I guess, reading Wi-Fi at 11:33.
It's reporting its location to Google at 11:33.
You've jumped ahead a couple days. So we had September 26th. Now we're looking at September 30th.
Yes, ma'am.
What are you depicting here, and what did you find from the records that you reviewed?
So this is showing on September the 30th, 2019, between 4:32 and 4:37 p.m. Starting at 4:32, the number ending 9120 is reporting its location to Google, consistent as being at Alex Cox's apartment. And then showing movement at 4:34, and by 4:36, the 9120 phone is reporting its location to Google, consistent with being at Lori Vallow's apartment.
Okay. And so that's where, when we're looking at that R15, that's the margin of error of 15 meters.
Yes, ma'am, correct.
So the phone is within 15 meters of being at Lori Vallow's.
That's what Google is reporting.
We're still at September 30th here.
Yes, ma'am. And so that's looking at the remainder of the day, going from September the 30th, from 4:38 p.m. all the way to 11:59 p.m. Approximately 94 different records, all consistent with the number ending 9120, reporting its location to Google as being in the area of Lori Vallow's apartment.
And so here, because you had so many Wi-Fi readings that are reportings, you just put that there were 94, well, I guess 93 Wi-Fi and 1 GPS.
Yeah, and basically what I was trying to look at is whether there were any instances that indicated that that device went back to Alex Cox's apartment, and I was unable to find any.
So we're on page 22. What are we now seeing here?
So again, at the top, I'm basically bookending the dates and times. So we're looking at two different uses of the Verizon network by the number ending 5998. The first one is on September the 30th at approximately 12:34 p.m., utilizing a tower and sector that's up in Rexburg, Idaho. And then the next use that we see is October the 1st, 2019, the same phone number ending 5998, using a tower and sector consistent with being down in Arizona.
So the 12:34 p.m., that's Idaho time?
That's correct.
So when we looked at the movement, that would be before we saw the 9120 phone associated to Alex Cox moving from Alex Cox's apartment to Lori Vallow's?
Correct. And I would point out that this is not showing that at 12:34 that device began heading south towards Arizona. That's just the record that I had at 12:34. So there was no other use between those two time periods, so I'm not able to estimate where that phone was during that time period.
Okay. So we know at 12:34 p.m. on September 30th, that track phone, the 304 number, is still in Rexburg, Idaho, receiving an incoming call at that time.
Yes, ma'am.
So let's talk about that call. Do you recognize that phone number, the 515-402-0143 number?
I do.
And that is a call being made to this Walmart track phone.
Yes, ma'am. Correct.
By whom?
So I have that number associated with Chad Daybell.
So Chad Daybell's phone is calling this Walmart track phone that just was activated a couple days earlier on September 30th at 12:34.
Yes, ma'am.
And then we don't see any call records for this track phone until October 1st, the next day.
Yes, ma'am. Correct.
We see on this map that you have 9:19 a.m. So this is Arizona time?
Yes, ma'am. Correct.
And so at this point, at 9:19 a.m. on October 1st, that track phone from Walmart in Idaho Falls is now using a cell tower in Arizona.
Yes, ma'am.
And do we have it? We've seen the prior box that showed an incoming call. When we talk about outgoing, does that mean this track phone is making that phone call to someone?
It does.
And so who is this track phone calling at 9:19 a.m. on October 1st?
It's the same number from the previous, Chad Daybell, the number ending 0143.
So map 23, what do we see here?
So since this is going back and forth between Arizona and Idaho, I tried to put the map of the specific state that it represents, just in case you're not familiar with a specific area. But this is showing on October the 1st, 2019, between 2:56 p.m. and 2:59 p.m., movement of the 9120 phone because it's reporting its location to Google as being 3 different locations along East Center Street in Rexburg, Idaho.
Some power to this. All right, so October 1st, 2:56 p.m. to 2:59 p.m. Idaho time, we see the 480-351 number associated to Alex Cox. His Google is reporting this location data.
Yes, ma'am.
Meanwhile, we see the track phone from the Walmart that also has been associated to the Homer J. Maximus Google account is in Arizona.
Correct.
What do we see in this next map?
So this is looking at October the 1st, 2019, from 3:10 p.m. to 3:36 p.m. The 9120 phone is reporting its location to Google, consistent with being in the area of the Self-Storage Plus in Rexburg, Idaho.
So did you ever view video from the self-storage unit from this time period of October 1st, 2nd, and 3rd?
I believe I did, but it's been some time since then.
You show some records there, so you were provided at least with information. Let me ask you this. Were you provided with information that Lori Vallow had rented a storage unit at this location at 433 Airport Road in Rexburg, Idaho?
I was, and one of those pieces of information was the receipt that you can see on the that page of the report.
Okay. And so when we're talking about the relevance of this, it was one of the locations in the original map that you were asked to look at during this time period?
Yes, ma'am, correct.
So to understand what we have going on October 1st, we have Lori Vallow renting a storage unit in Rexburg, Idaho at this time on October 1st.
That's based on the receipt that I was provided. That would be the extent of my knowledge.
At the same time, you have the cell phone associated to Alex Cox reporting Wi-Fi and GPS location data to Google at the same time that this is all, that Lori Vallow is renting this unit.
Yes, ma'am, correct.
What do we see then in map number 25?
So this is close to the same time period as the page before, October the 1st, 2019 at 3:24 p.m. And this is showing use of the 4652 phone for 2 incoming calls, utilizing a tower and sector in Rexburg, Idaho, that would provide coverage to the area of the Self-Storage Plus.
All right, so the previous map was about 310 to 336. So this is in that time period towards the end of it. The phone number we're talking about is the one that we've associated to Lori Vallow?
Yes, ma'am, correct.
And so when we see this cell tower use, is that a cell tower that would be consistent with providing coverage to the storage unit?
Yes, correct. And I say that because I'm familiar with the area and familiar with the terrain. And that's why I'm able to say that that tower and sector would provide coverage to that general area.
Okay. Now, when we're looking at this time, we see 3:24 p.m. Idaho time. What would that be Arizona time?
So Arizona is 1 hour behind, so that'd be about 2:24.
So at 2:24 Arizona time, this 480-266-8587 number is calling Lori Vallow's cell phone.
Correct.
And is that 480-266-8587 number the one you told us is associated to Melanie Boudreaux?
Yes, ma'am.
And so all of this is going on while we also see Alex Cox's cell phone providing that GPS and Wi-Fi data for being in the area of that storage unit as well.
Yes, ma'am.
So we're continuing on October 1st in this, still in Idaho?
Yes, ma'am. This is October 1st at 5:17 p.m. Again, the 9120 phone is reporting its location to Google, consistent with being in the area of the Rexburg, Idaho Temple.
So we've been talking about October 1st. When we get to page 27, are we now on October 2nd?
Yes, ma'am.
So we had some cell phone or one cell tower use by that Walmart track phone on October 1st. Are you now reflecting cell tower usage by that track phone on October 2nd.
Yes, ma'am. So this is showing records associated with the 5998 number between October 2nd, between 7:02 and 7:20. Starting over on the left side using a tower, two different sectors on a tower, 7:02 to 7:09 on the sector facing west. And then we see a shift at about 7:17 to utilization of the tower facing north-northeast, sector facing north-northeast, excuse me. Then by 7:19, we start to see use of a tower and sector that's just east of that location. My examination of these records, I would say it's consistent with that device likely moving eastbound.
So from 7:02 to about 7:18, the Walmart track phone from Idaho Falls, Idaho, is using cell towers in the area of Melanie Boudreaux's residence.
Yes, ma'am, that's correct.
And then after 7:18, that cell phone, track phone from Walmart in Idaho Falls, Idaho, is now utilizing a cell tower closer to Brandon Boudreaux's residence.
Yes, ma'am.
Is this a continuation of that morning reflecting that Walmart track phone?
Yes, ma'am, it is.
Can you tell us what this map is showing us?
So this is showing the same thing, the 5998 phone on October 2nd between 7:22 and 7:24, utilizing two different towers, and specifically the tower more in the middle of the page, two different sectors on that tower, consistent with being in the area of Brandon Boudreaux's residence.
So from 7:22 to 7:24, we're seeing cell tower use from that Walmart track phone, consistent with it being in the area of Brandon Boudreaux's residence.
Yes, ma'am.
And this is the same cell phone we're talking about that has been associated to Alexander Cox's homerjmaximus@gmail.com Google account.
Yes, ma'am.
So we went back to Idaho in this photo?
Yes, ma'am. So this is back in Idaho in Rexburg, and this is showing on October the 2nd, 2019 at 8:02 in the morning Arizona time, which would have been 9:02 up in Idaho. But there is an outbound call made from the number ending 9120 to the number ending 4652. This call is a little bit over 23 minutes. And during the call, both phones are using the same tower and sector, both of which provide coverage to the apartment complex that had Lori Vallow and Alex Cox's units in it.
So basically we have the cell phone associated to Alex Cox, the 480-351-9120, calling the cell phone associated to Lori Vallow, 480-489-4652 at 9:02 Idaho time.
Yes, ma'am, correct.
8:02 Arizona time.
Yes, ma'am.
And that call you said was not quite 24 minutes?
Approximately 23 minutes and 34 seconds.
While that is going on at 8:02 a.m., we've seen just a little earlier that the Walmart track phone from Idaho Falls is now utilizing cell towers in Gilbert, Arizona?
Yes, ma'am.
Now, during this call, did you have any Wi-Fi or GPS location data for that Homer J. Maximus Google account associated to that 351 number?
Yes, ma'am. There was one at 9 o'clock and 9:10, both consistent with the 9120 phone being in the area of Lori Vallow's apartment. But I'll also add to that, that entire day, that phone only reported being in the area of Lori Vallow's apartment, not Alex Cox's.
So basically, we continued what we saw from the day before, other than we saw, well, let me say this. So we saw the phone going over to the phone being the phone number associated to Alex Cox, the 9120 on the 30th, move over to Lori Vallow's apartment.
Consistent with that, yes, ma'am.
And then we saw location data provided to Google for that same phone, the 9120, moving at some point away from Lori Vallow's residence, going to, for instance, on the first, an area near the self-storage unit,
Yes, ma'am.
going to the temple,
Yes, ma'am.
and then returning back to Lori Vallow's apartment.
Yes, ma'am.
And then we have, on the 2nd in the morning, this phone call between Lori Vallow's cell phone, the one associated with her, and Alex Cox's cell phone, or the one associated with them.
Yes, ma'am.
So as we get to slide 30, what are we reviewing here now? Where are we at?
So we're back in Arizona looking at records for 5998. Here we're looking at October 2nd between 8:39 and 9:16 a.m. And the 5998 phone is utilizing a tower and sector in the general area of Brandon Boudreaux's residence. And there's 3 outgoing calls, 2 incoming calls, all from the number ending 0143.
Is that the phone that has been associated, that you are aware of, associated to Chad Daybell?
Yes, ma'am.
And Chad Daybell is Lori Vallow's husband?
I'm not sure if she was at the time, but that's my understanding now.
So when we look at this phone, were you aware that the shooting of Brandon Boudreaux at 3875 East Phelps Street occurred around 9:13 or so in the morning?
It's been a period of time. I know it was sometime around then, but I wasn't sure the exact time.
So in the time period leading up to right around that 9:13 time, that's track phone from Idaho Falls Walmart is utilizing cell towers in Gilbert, Arizona that would cover the area of Brandon Boudreaux's home at 3875 East Phelps Street.
Yes, ma'am.
What do we see here on map 31?
So here we see starting on October the 2nd at 9:17 in the morning, use of a tower and sector facing north on that tower, showing use of the 5998 phone, and that tower and sector would provide coverage to the area of Brandon Boudreaux's residence. Then we see a shift starting at 9:19 to a sector that's facing more southeast, and continuing through 9:22, we see use of a different tower southeast of that location, consistent with that device moving southeast out of the area.
So if we had received information that the shooter in this case moved south to Pecos Road that we see here in the map and then headed away, is that sort of the same direction that we're talking about? The cell phone is using towers in that same direction?
I would say it's consistent with that movement.
And then we see the cell tower as the morning moves on, going further south and east?
Yes, ma'am. I would just say southeast, based on the tower locations that I was looking at in the records.
And obviously, you're not able to tell us exactly where this cell phone is because it doesn't have the Wi-Fi or GPS location data being reported, correct?
I'm only estimating locations based on the records that I have, and the records that I have are going to dictate how precise I can be with those estimated locations.
So here we know the cell towers that are being utilized by this phone during the morning there.
Yes, ma'am.
And again, when we look at these phone calls, incoming and outgoing, were all of them being made or received by that same phone number associated to Chad Daybell?
So here we're only looking at one call, but yes, that call is to the 0143, and it's an outgoing call to that number.
So we have cell towers that are reporting the phone, and then we also have phone calls starting to be made.
Correct.
Okay. So the first call we see after the 9:15 one from the prior page is at 9:22, which is an outgoing call to Chad Daybell's cell phone.
Yes, ma'am.
What do we see now here on page 32?
So this is looking at Google location information on October the 2nd, 2019, between 9:02 and 9:34. The 9120 phone is reporting its location to Google, consistent with being at Lori Vallow's apartment.
Okay. And you've told us that sort of this has been, at any time from the 30th, when you documented that cell phone associated to Alex Cox, the 9120, moving from Alex Cox's apartment over to Lori Vallow's. From September 30th through this time at 9:34 a.m. on October 2nd, did you ever see the phone move back to Alex Cox's apartment?
No, ma'am, I did not.
Slide 33.
So this is back in Idaho, showing the usage of the number ending 4652 on October the 2nd, from 8:50 in the morning to 9:46 in the morning, sticking with Arizona time based on the fact that there was an incident that occurred in Arizona. So between 8:50 and 9:45, there's 5 instances where that phone is on the network and utilizing a tower and sector consistent with providing coverage to Lori Vallow's apartment. And there's 2 outgoing calls, 3 incoming calls. There's 1 outgoing call to the number ending 8587, which was associated with Melanie Boudreaux. That call's a 35-minute call. And then there's 1 outgoing and 3 incomings with 0143. That number I had associated with Chad Daybell.
So since this is Arizona time, at 8:53, this would be before the shooting occurred in Arizona, if that occurred at 9:13.
Yes, ma'am, correct.
Okay. So prior to the shooting in Arizona, we have an outgoing call to the number associated to Chad Daybell,
Yes, ma'am, at 8:50.
and then an outgoing call associated to a phone for Melanie Boudreaux, and then an incoming call associated to the number for Chad Daybell at 9:01.
Yes, ma'am.
And then there is a break in time before there is an additional incoming call at 9:44 and 9:45, both of those from the phone associated to Chad Daybell.
Correct. And I would just point out that that 1 call at 8:53, that's an outbound call to the number associated with Melanie Boudreaux, is a 35-minute call, so it could have spanned a large portion of that time window.
So when we see the incoming call at 9:01, how does that work if she's on the phone outgoing?
I need to look at the specific call detail record, but that very well could just be call waiting to where both calls occurred during that same time window, but I wouldn't be able to answer that question with the records I have in front of me.
That call is just 2 minutes, 2:09.
Yes, ma'am.
And then when we see the 9:44, we see that's just a 3-second initial call, and then at 9:45, a 7.5-minute call.
Yes, ma'am, correct.
Slide 34. What are we seeing here?
So now we're zoomed out again because we're showing 2 vastly different locations of where towers that were utilized by the 5998 phone were. So we're looking at October 2nd between 1:22 p.m. and 8:13 p.m. Starting at 1:22, the 5998 phone is utilizing a tower and sector in Arizona, kind of northeast of Phoenix. And then by 7:53, the phone is utilizing a tower and sector in Utah.
When you're looking at this and you reviewed the records, the call that we see at 8:12 p.m. incoming from the phone associated to Chad Daybell, that's a 29, almost 30-minute call.
Yes, ma'am.
Is that the last call that is documented for this Walmart track phone from Idaho Falls?
There are additional calls, but I'll explain it like this. So whenever you're looking at a call detail record, if there's an incoming call and then there's duration and there's a tower and sector identified, that shows that that phone was on the network and we can show that that call connected. There's additional calls after that that don't populate those columns that would be associated with the tower. And so because of that, you could have incoming calls that would just basically go straight to voicemail because that phone is no longer on the network. So the 8:12 p.m. was the last record I saw in the call detail record where the phone was on the network to receive a call.
So slide 35, what state are we in? What are we seeing here?
So we're back in Rexburg, Idaho, and we're looking at October 3rd, 2019 at approximately 2:15 p.m. The 9120 phone is reporting its location to Google, consistent with being in the area of the self-storage plus.
And so we see 2:15 p.m. Wi-Fi data of that a phone associated to Alex Cox at the self-storage unit?
Yes, ma'am, correct.
And then were you also provided with video to show that at 2:13 p.m. There are two individuals removing a tire and another item, a bench seat, from the storage unit that was rented by Lori Vallow?
Yes, ma'am.
Slide 36, what does this show us?
So this is showing use of the 4652 phone, October the 3rd, 2019, between 2:20 and 2:22. And the phone is using a tower and sector that would provide coverage to the apartment complex for both Lori and Alex.
So on October 3rd, we now have the phone associated to Lori Vallow, receiving calls from the phone that has been associated to Chad Daybell.
Yes, ma'am.
And that phone is using a tower consistent with them being in Rexburg, Idaho.
Yes, ma'am.
Were there any other network calls that you saw for that phone from the Walmart Idaho Falls track phone?
No, not after the call that was made in Utah.
And did that end your mapping of the data provided to you by the Gilbert Police Department in relation to this case?
Yes, ma'am, it did.
State has no other questions for this witness.
All right, Cross?
Do you want me to call you Special Agent or Mr. Balance or?
Special agent is fine.
Okay. Special Agent Balance, I just have a couple questions. You had mentioned that if all of your, okay, so you had mentioned if all of your locations are on, which one would it track? So say you have 3 phones associated to your Gmail account and all the locations are on, what would it be tracking?
Yeah, so if you were to look at the location history where you had 3 different devices that were reporting that location, whenever you look at the record, they have a column called device tag.
Okay.
So they would differentiate that device tag, that's a number Google provides, but that device tag would be associated with each individual device. So as an example, if you were looking at, you only wanted to see the Google location for phone 1, you would need to know the device tag associated with phone 1, and you could filter out and see just where that device was. Same thing with phone 2 or phone 3, depending on how many devices are reporting location information.
So if all 3 had their location on, then all 3 would be reported, even if they were in different locations?
Yes, ma'am, that's correct.
Okay. And then what about if you have, so you're talking about a track phone being connected to a Gmail account, is that correct?
Yes, ma'am.
And then what if you have an iPad, a laptop, and a phone all connected to the same Gmail account?
So it would depend on, again, that device tag column and the device itself. So the device would need to be able to report location information Google would need to be able to derive that location information by some method. So if you had location information turned on all those different devices, it would really just depend on the device, how it reports it, but it would show up in that same location history record.
So if you're tracking something and you say phone 1, you don't want the iPad, you don't want the laptop, you're tracking phone 1, you would be able to distinguish that out by that number of phone 1?
So I would look in the Google record, the entirety of the record, it would tell you which device tag is associated with which device. And so then I could differentiate which device was being reported and which ones weren't.
Now, where did you get your, who sent you the information from Google? Did you get that directly from Google? I had missed that.
No, so those records were obtained via search warrant. I believe it was somebody from the investigative team in Rexburg,
Okay.
but I wouldn't be able to provide you a name of who sent those records down.
And how did those records come to you? Like an email or something? Or how
Yes,
did you-
ma'am, they would usually be sent via email.
So is that like, it's a lot of data, right? So is it one giant email or several emails? How does that work?
It depends. Specific to this case, I can't remember whether it was sent via email, but we do have options to send larger files. And so if it's a Google record that has location history, has a bunch of different services that are being utilized by that user, it could be a very large file, and then it would be sent electronically to me.
Through like a hard drive or a flash drive, something to that effect?
We have some ways that we can send it electronically that they're capable of transferring larger files, per se.
And so the data that you received from this email or from a larger, did you receive it from an email? You don't remember if you received it from an email, is that correct?
I don't recall. I would say that given this particular file, I know it was larger, so I would guess that it probably came via some type of transferring platform versus email.
Okay. And then if you don't know who you got it from, how do you know if that information is accurate?
So I'm basically mapping out records as I receive them. So I would look at the certificate of authenticity. I would ensure that it's a record that came from Google. But aside from that, I'm mapping records as I receive them.
So you don't have any way to know if it was altered before it got to you, basically?
Correct.
Okay. And you're saying that you're getting all of your information directly from Google, so would it be different information if you had the phone itself? Or are you getting all the information from Google that you would have with this phone?
So with CAST and the specific unit that I'm assigned to, we're not looking at information that comes out of the device. We're looking at the records that were generated with particular providers. So although we could get information additionally from the forensic download of a phone, what we're looking at is those records from the providers that are maintained separate from the phone, if that answers your question.
So my question is, would you have more information if you had the phone?
Yes, absolutely.
Okay, so you could track it better, per se.
I wouldn't say better. I would just say that you could potentially have more information that would help determine whether the records are consistent with the overall picture of what both the carrier records are showing and what the phone records are showing. So as an example, my phone right now, if I'm sending text messages back and forth, those messages have content, they have context of, if I say I'm on the way to the airport or I'm gonna leave here in 10 minutes. Separate from that, you have the records from Verizon that would show feasibly where my phone was. Now, if you marry those records up, you definitely have more information and you could tell the story better, but one's not necessarily better. It just depends on the circumstance.
So one doesn't negate the other, it just confirms it.
Sure.
Okay. So is it typical, would you say, for people to have more than one device associated to their email?
Yeah, this day and age, I would say so, just because a lot of people have more than one phone.
And you could have multiple devices, like 5 iPads and 5 phones and a couple computers all generated and giving Google information from the same Google email?
Sure, it depends on what your, it's going to be dependent on every single individual, but yeah, if you have an iPad, a laptop, a phone, and you connect all those to your Google account, like it's not unreasonable for me to see records associated with multiple devices that have access to Google account.
Okay. And you can't put a person anywhere, right?
So anytime I'm estimating a location of a device, it's not an estimated location of a person, it's an estimated location of a device. And it really depends on the records that I obtain. So while I've been very successful in determining a location of an individual based on their device, it depends on the records of whether that search area is smaller or larger.
Okay. So if you were to give a teenager a phone associated to your email account, and they're at an amusement park going on a bunch of rides, and then you're doing a download, it could look like you were in all these places, but you were really not. Is that true?
Can you rephrase that question a little bit?
So if you just had a track phone that was associated to your Gmail account and anyone else had it, it would look like you were in that place.
So the device, if the device is reporting to Google its location information, then I would look at those locations that it's reported as the areas where that phone was at a particular date and time.
Right. So you can't put a person anywhere, but you are locating the device. Is that correct?
Correct. I'm locating a device.
Okay. Do you remember about what you had said that on October 3rd at 2:15, the device was at the self-storage plus. Was that the track phone?
No, that was the number ending 9120. So that was reporting its location to Google as being consistent with being at the self-storage plus.
And did the track phone ever, I want to say ping, but give a location in Rexburg after October 3rd?
Not after October 3rd, no ma'am.
Do you remember the last time when it did?
I know the last time in the call detail record was that page where it showed the phone being used in Utah, and I believe that was October the 2nd towards the evening hours.
Do you know where in Utah that last location was?
If you were to pull up that page on the report, I could give you the area, but I know it was southeast of Salt Lake City.
Okay. There was something about the meters. So when you were talking about, on page 6, you show the 3 slides with the sectors.
Okay, are you able to pull up page 6?
Oh, I'm sorry. Sure.
No, you're fine.
Is it okay if I just hand it to him? Or do you want it? You can put it on the... You want it on here?
Yeah.
Oh. Yeah. I don't know how to work it though.
It's okay.
Oh, you got Zoom.
Technical.
top. The button. Roll. Oh, there we go. Roll it. The other way.
There we go.
Roll.
Sorry. I just wanted to ask a question about the meters.
Sure.
So you had said something about, is it 150 meters in each of those sectors? Was that what I heard?
So it's degrees instead of meters. So basically what you're looking at is how a sector is divided up of a tower. And so specific to this one, I think I was mentioning sector 1. And when you talk about the azimuth or direction from the tower that that particular sector is facing, you would use that azimuth in degrees to give you that direction.
So with the two apartments being so close in proximity, and you were talking about that it's pinging on a cell tower that shows both, so I'll show you this one. I think it's this one. 18 maybe. So this circle right here that's both apartments are within that same, is that cell phone coverage?
So that specific graphic there, when you're looking at that circle, all that circle is doing is showing the direction from the tower of where that specific sector is providing coverage to. So in this instance, that tower, that sector is facing northwest, and that particular tower and sector is providing coverage to a great deal of Rexburg, but included in that coverage would be the apartment complex for both Alex and yourself.
And so, do you know how far apart those apartments actually are?
I know they're fairly
Meters?
close. It's been a while
Oh, in
since
meters, but,
since I've been out there. It's been a while, but I know there was maybe 1 to 2 buildings between, but they were relatively close.
so are you able to tell from, location-wise, are you able to tell the difference with a cell phone tower, or is it some other way that you're, do you see what I'm saying?
I do.
Okay.
So with this particular tower and sector, that usage at 1131, there's no way you could say definitively that that phone was at Alex's apartment, was at your apartment. You're just basically saying that's utilizing a tower and sector that provides coverage to that area. So the phone could be anywhere within that coverage area whenever that particular call was made.
Okay. But there is a way to distinguish if it was at either one, but it's not that cell phone tower.
Not via the call detail records from Verizon. You would need the Google location history, which is giving a much tighter margin of error associated with that device.
Okay, that makes sense. Thank you. So when you had spoke about the Walmart, I don't know what page that is, but you were showing that according to Google, is that correct? That a phone associated with me and a phone associated with Alex were in that Walmart shopping center? Is that
So I
correct?
think you're talking about page 16. So there's 2 different pages associated with that statement. The first one is the 9120 phone reporting its location to Google, and that's where you can see multiple locations consistent with being at that Walmart in Idaho Falls. The page following that is looking at the phone associated with you that was utilizing a tower and sector that would provide coverage to the general area of that Walmart. So it's 2 different, basically, versions of records that are providing 2 different estimates as to where those 2 phones were.
Because one is a phone call, so it has an outgoing tower. Is that correct?
So one is looking at the Verizon network, and so it's utilizing that specific tower and sector for that. I can't remember whether it was an incoming or an outgoing call. Whereas the Google location, that's information that that phone is reporting from either GPS or Wi-Fi to Google as where it's located during that same time period.
So could it connect to Walmart Wi-Fi? Does Walmart have a Wi-Fi?
So it wouldn't need to. If Walmart had a Wi-Fi, it doesn't necessarily need to connect to it. It just needs to see it, because when the phone takes a measurement and sees that it's has a certain signal strength from that Walmart Wi-Fi, then it is able to estimate where that phone is because Google knows where that particular Wi-Fi hotspot is located.
Do you have the ability to track someone walking around in a Walmart?
I mean, if you looked at the Google, if you're looking historically and you wanted to see, like, did an individual go to a particular aisle in Walmart, I think that would be a stretch, unless it's a very big Walmart and you're just trying to see whether they were in landscaping or over on the grocery side. It all depends on the information that you have in that record from Google. So if those margins of error are super small, you could potentially estimate that, but it really would just depend on the record that you have specific to the device that you're trying to locate.
And if you had the actual device, could you pinpoint that more accurately?
Again, it would depend on the device and what apps you're running on the device and what all is being potentially stored. So different phones have different ways that they store information. They have different GPS chips inside of them. Apps have different ways that they store information. And so it would really just depend on getting that phone, doing a forensic download of that phone, and seeing what you have.
And then could you compare that to the Google information that you got and have a much more accurate picture?
I wouldn't say you would always have a more accurate picture because you might not have any records that you might do a forensic download and you're not able to pull out any location information. I would say that it's always better to have more information to do that comparison, but it's not a guarantee that it's going to make it better by having the forensic download of the phone.
So it would be more accurate as far as locations from Google?
I wouldn't say it'd be more accurate. It's just, it's a different record, you know? So if you have a Google location record that has a significant number of locations, they're all 2-3 meter hits because you were potentially standing outside, that's going to be pretty precise. But it's kind of speaking in, it really just depends because you don't know what that record's going to look like until you get it and you review it.
So if you don't have your location on, are you able to track where things are, or only if it connects to a Wi-Fi?
So again, it's going to depend on the specific app that you're speaking about. So like if you go into your phone, you can turn location services on or off for a lot of different apps. And so whenever I'm evaluating records from places like Google or different applications that have stored that location data. So it really just depends on how you have your specific phone set up and what you've opted into or out of as far as location sharing.
Okay. So basically, your report is indicative of phones associated to certain emails in certain locations at certain times.
So the one phone is associated with the Gmail account. That's the 9120.
Okay.
The other two phones I'm looking at Verizon records. So it's
Okay.
basically what Verizon maintained for those specific numbers.
And is one more specific than the other, the one with Gmail or the two with Verizon?
I would say that the locations being reported to Google had smaller areas to estimate where the device was. When you're talking about the Verizon records, the records that I had, I'm only able to estimate a general area based on what the coverage of a particular tower and sector provides coverage to.
Okay, and what is the radius of that, the tower coverage of Verizon?
So if you go back to some of my earlier statements, it's going to depend on where you're located. So downtown Phoenix, tower density follows population density. So the coverage areas in downtown Phoenix are going to be a lot smaller than if you get out into rural areas where there's just not as many users. Mm-hmm. And so because of that, that coverage area is going to be large. Typically, I estimate that the coverage area of a tower is going to be the area between that tower and the next tower closest to it.
So with the Verizon records, that was the one that would say 16 meters or 15 meters. Was that with the Verizon records?
No, that would have been the Google location if it's what I think you're referring to, where there's a margin of error with a circle around it. That's solely from Google. That would not be from Verizon.
Okay, so with Verizon, it's more accurate, and with Google, it's with the meters, within a certain amount of meters?
It's the way that they're measuring. Google's providing their margin of error. Verizon is not. For Verizon, when we're estimating a coverage area, I'm using my training and experience of locating phones historically and estimating that phone, what the coverage area is going to be for the tower and sector that phone used.
So is it which one, the Gmail or the Verizon that is giving you the information that there was no moving of the phone from one apartment to the other?
So whenever I made that statement, it's based off the Google location history. And so what I'm looking at is, for a period of time, every Google location, every line in that Google location history record. So whenever I'm looking at those and I don't see that device has either moved or gone to Alex Cox's apartment, that's all from the Google location record.
Right, so if a phone was just in a car driving around, right, then it would show it in movement everywhere that car went?
It would depend on if it's reporting its location during that movement. So let's say, for instance, that car left a parking lot of that apartment complex and drove 15 minutes north and then 15 minutes back. As long as there's a Google location record during that 30-minute window, that's where I would be able to say that there was movement. But if there's a record at 9 o'clock in the morning and then there's not another record until 9:30, I can't say definitively that phone didn't move during that 30-minute window. All I can say is this is where it was at 9 o'clock, and this is where it was at 9:30.
Because it's not reporting.
Correct. Okay. Every estimate that I make is based on there has to be a record in a line of a record for me to determine a potential location.
So can you explain that to me, what it's reporting? So if a phone is off, it's not going to be reporting anything. But if it's just sitting there stagnant, it's not going to be reporting anything?
It depends. Typically, I've seen in records that I've reviewed on a regular basis, if a phone is stationary, it's not going to report as much. And if it's moving, it potentially would report more. But again, the phone has to be on and the phone has to be opted into location history. And that's what's going to generate that record that's maintained by Google that I can then evaluate and see potentially where a phone was in the past.
Okay, so you have access to what is being reported.
So I would have access to the Google location record.
Right, only what the phone is reporting or what the device is reporting.
To Google, yes.
Okay. And you made your report off of what was reported, and it's not, I'm just trying to get to, it's not constant. You're not getting a phone record from, like, say, September all the way through October, and you know everything of where that went, because it wouldn't be reporting all that time. Is that accurate?
So I'll give you an analogy. Maybe this will potentially help. But if you think about you live next door to your neighbor, and your neighbor's car is in the driveway. They've got a red car in the driveway. And so at 9:02 in the morning, you go and look, the neighbor's car is in the driveway. 9:45, you go and look, and the neighbor's car is in the driveway. And then one more time at, say, 11 o'clock, you look, and the neighbor's car is in the driveway. You can only say that the neighbor's car was in the driveway at those specific instances because that's when you looked out the window. You could reason that maybe that car was there the entire time, but you can only definitively say where that car was when you have an instance that you looked out the window. So it's the same thing with the Google location record. So I can estimate where a device was as long as there's a date and time, a latitude and longitude, and a margin of error. If that's not present, then I'm not able to estimate during the window of inactivity where that device is.
So in your timeline, there could be blind spots where you don't know where the phone was or the device was or what it was doing.
If there's not a location record, I can't map it.
Okay, thank you.
Yes,
Redirect.
So Detective, in your years working as a CAST agent, have you reviewed multiple Google records,
Yes, ma'am.
Verizon records,
Yes, ma'am.
track phone records?
Yes, ma'am.
And you told us that part of your process is to always look at the certificate of authenticity.
Yes, ma'am.
Was that done here?
Yes, ma'am.
Did anything about these records appear to be unauthentic or modified?
No, ma'am.
When you are mapping and creating these maps for us, are you just using the data and just showing us what it says?
Yes, ma'am.
In this case, you were given Alex Cox's Google or Gmail records for the homerjmaximus.com, right?
Yes, ma'am.
And that included location data.
Yes, ma'am.
And you were provided with records showing that that Gmail account was associated to the 9120 number.
Yes, ma'am.
And you were also provided, and those Google records is what gave us the GPS and the Wi-Fi location data for that cell phone, 480-351-9120.
Yes, ma'am.
Then you also had the Walmart track phone, correct?
Yes, ma'am.
That phone was not reporting Wi-Fi or GPS data. You did not have any for that phone.
No, that phone was not reporting any location information to Google.
But based upon the Google records you had for the homerjmaximus@gmail.com, you were able to determine that Walmart track phone had accessed and associated with that homerjmaximus@gmail.com address.
Yes, ma'am. That phone accessed that Gmail account.
Okay. So when you're talking about the Walmart track phone, all you were able to map on that was cell tower use.
Yes, records from Verizon.
When we talk about the Walmart on September 25th of 2019, we have both the phone associated with Alex Cox, the 9120 phone that you mapped there, right?
Yes, ma'am.
And that mapping was again using the GPS and Wi-Fi.
Yes, ma'am, as reported to Google.
And that was, you were able to map that within as small as 16-meter radius.
I believe that's correct, but I'd have to look at the page to ensure the
Okay.
margin of error.
Just gonna throw this one up to make it faster.
Yeah, so the most precise was the 16 meters.
So it's in the Walmart.
It's consistent with being in the Walmart.
So unless the Walmart's smaller than 16 meters, pretty likely it's there, especially given the number of hits that you had in that location.
I'll say that if I were looking for that device and it was, 7:15 right now, and that's the records that I was seeing, I would go inside the Walmart to look for that phone.
Okay. Now, on the other hand, you also had cell tower usage for the phone number for the phone associated to Lori Vallow, the 4652 number, correct?
Yes, ma'am.
And you did not have GPS or Wi-Fi for that.
Correct. That phone was never reporting location information to Google that I had.
So for that case, you were using cell tower data.
Yes, ma'am.
And you were able to determine that that phone was using a cell tower in the area of the Walmart at the same time as this phone is showing Wi-Fi location data at the Walmart.
Yeah, I think that was at 7:08 p.m. if I remember right.
So it would be in this time frame of 7:07 to 7:16,
Yes, ma'am, correct.
and we see over there 7:08. So basically, both of those two phones, the phone associated to Alex Cox and the phone associated to Lori Vallow, are either showing specifically Wi-Fi location data in the area of the Walmart or using a cell tower in the area of the Walmart.
Correct.
I have no other questions for this witness.
Are there any questions for this witness from any member of the jury? I don't see any. Sir, you can step down.
Your Honor, Honor, at this time, the state is going to rest.
All right, the state has rested. That means the state's done with its presentation of the evidence in this case. At this time, we'll take our noon recess. Please be back in the jury room, ready to go at about 1:20 p.m., please. 1:20 p.m. Please remember the admonition.
All rise for the jury.
Does the defendant intend on putting on a case, any witnesses or testifying?
We plan on doing our Rule 20, Your Honor, and no.
Okay, go ahead with your Rule 20.
Can we do that when we get back from lunch?
Sure. If you're telling me you don't plan on testifying or you don't plan on calling witnesses, let's finalize the jury instructions though right now. Did you get a chance to look at those?
We did.
All right. Let me go to the state first. Why don't we do it this way? We'll just go through one page at a time to make sure everyone's on the same page. So the cover page, then page 2 is duty of the court, evidence to be considered, rulings of the court. Those are standard. Any objections to those from the state?
No, Your Honor.
Defense?
No.
Page 3, direct and circumstantial evidence, redacted exhibits, indictment not evidence, self-represented defendant. Any objection to those from the state?
No, Your Honor.
From the defense?
No. No.
Sorry, okay. Page 4, comments are not evidence. That was modified a little bit because the defendant represents herself. Credibility of witnesses, testimony of law enforcement officers, expert witnesses. Any objection to those from the state?
No.
Defense?
No objection.
Page 5, defendant need not produce evidence, defendant need not testify, voluntariness of defendant's statements, and then the start of the jury not to consider penalty. Again, all standard. Any objections from the state?
Judge, we actually have no statements by the defendant, so
That's true. We could probably delete that. There were, yeah, I think that's right. There were no statements, so I would intend on deleting that. Anything else from the state?
No, Your Honor.
How about from the defense?
No, we agree.
You agreed that that should be deleted?
Correct.
Okay. Page 6, presumption of innocence, burden of proof, evidence of any kind, voluntary act. Any objection to those from the state?
No.
Defense?
No objection.
Page 7, the absence of other participant, motive, and then the charged offense starts with the charged offense and then defines what is first-degree premeditated murder. Any objections from the state?
No.
From the defense?
No objection.
All right, page 8, a definition of premeditation. Then we have the elements of conspiracy, scope of proof of conspiracy, and proof of membership in a conspiracy. Any objection to those from the state?
No.
Defense?
No objection.
Page 9, definitions, intentionally, knowingly. A part of the accomplice. Any objection to those from the state?
No.
Defense?
No objection.
Then top of page 10, accomplice, act, and I don't know why aggravated assault in there. I
that's-
must have left that in from the last one. I'm going to delete aggravated assault. I think that was on the crime prevention from our last trial, so my mistake on having that in there. I'll delete that. Other than that, any objections from the state?
No.
Defense?
No objection.
And then we have the jury foreperson and the closing instruction. Any objection to those?
No.
Defense?
No objection.
And then we have a form of verdict. Any objection to that from the state?
No.
Defense?
Oh, I'm sorry.
No objection to it.
All right. Any others that I haven't included that the state is requesting.
No, Your Honor.
Defense?
Your Honor, we would ask for mere presence, just because they put up the videos of me being at the storage unit at that time.
Well, mere presence would apply to the crime scene itself.
I understand that, but I
would
think
think.
it would cover it.
I don't think it's applicable, but I don't mind including it if the state agrees with the state's.
Given it's the conspiracy to be safe, I'm fine including it
Okay,
in there,
we'll add
Judge.
mere presence back. I think I had it last time. I will probably put that. How about if I put that right behind absence of other participant before motive? In that area, it makes sense, I think.
That's fine.
All right, any other additions?
That's
All right,
it,
so
Your
when
Honor.
we come back from lunch at 1:20, the defendant will do her Rule 20 motion. When this when the jury comes back in, I'll turn to the defendant who is telling me she's going to rest her case at that time, and I'll read the instructions, go right into closing arguments. All right, thank you.
All rise. Oh, I'm sorry.
Well, here we are, Fox 10 investigator Justin Lum here. You are watching coverage of the Lori Daybell trial, the final chapter. Truly, we did not really see anything different. This news that she's not going to present any evidence, testify on her behalf. She has no witnesses, so everybody who's been following this case was pretty much right on the mark that Lori Daybell doesn't have anything to present, so we will have closing arguments at some point this afternoon. Jury instructions will be read as well. But first things first, the Rule 20 motion. She did this last trial as well. Even though she's not going to present any evidence, she is going to present her argument after lunch to Judge Boreski and claim that the state did not present substantial evidence that proves, beyond a reasonable doubt that she conspired with Alex Cox in this shooting. She's going to ask for an acquittal. This is uniform or protocol. She has nothing else to do. The judge, we foresee, is going to deny that. And we'll get into closing arguments. But Nick Balance, dry technical testimony, a lot of cell phone data. She tried to poke some holes in that, but the bottom line is investigators locating, placing a device in these areas. Not necessarily the person, but circumstantial evidence.
Yeah, we wondered too whether Balance was or should have been called earlier in this. We weren't sure why the state chose to end their case with Balance. We thought maybe Hermosillo yesterday, his testimony would have been better to end on, but maybe there's a theory behind that. Maybe it was scheduling. We do know there were a number of scheduling issues for the state and their witnesses. So, somewhat dry. I was trying to take notes similar to what maybe a jury would do regarding cell phone numbers associated with individuals and where those phones were in this time frame of October 1st through October 3rd. Those 3 days, if you will, are so key to this shooting. Where was Lori? Where was Alex? Where was Alex's cell phone? Where was the track phone? Mm-hmm. We obviously know where the Jeep was. So we thought, look, there's going to be a time when this must be confusing. For those watching, we reminded everybody the court ordered we could not show Balance's face. It's the FBI special agent. They wanted to hide his identity on camera. So that's why we only saw shots from inside the courtroom. But the jury, at some point, the camera panned up. They were being shown maps, a lot of data. So, yes, very dry. Not that it's not important, but
very important.
But in the setup to all of this, maybe his testimony is a little bit better before we get to Hermosillo. But then also there was a lot about the phones being in the proximity of the storage unit, and so you almost felt like maybe she had to establish Trinity K anyway, had to establish the images that we saw from the storage unit and before getting to Balance's testimony. So a lot of strategy involved, but we'll see if today's testimony or even combined with yesterday's with Ray Hermosillo, if that was enough to convince the jury that, again, that she conspired with her brother, Alex, to shoot at and take out Brandon Boudreaux back in October of 2019.
Yeah, it could be scheduling too. Hermosillo from Idaho, out of state, also with Nick Balance. So maybe she wanted to have Hermosillo on last. Maybe Trina did want it, but sometimes it's just about scheduling. They get Balance in today. Sometimes it's not quite the knockout punch, but like you said, important testimony on the real hard evidence regarding cell phones, because that's a big player in this alleged scheme. All right, let's go right to our expert panel. Can't wait for this because we got some stuff to talk about, not just the Rule 20 motion, but Lori's motions that were denied earlier this week. She's saying she was in fear of Judge Boreski following the whole kicked out of the courtroom, timeout, or whatever you want to call it, last Friday. She also wants to recuse Judge Jennifer Green, trying to, clash with her for denying her motion to remove Judge Boreski on the case, and was denied by a third judge who had to step in, Judge Kevin Wine. She said she was having a virus and she was, not getting water. I mean, just multiple things that weren't even really taken into serious consideration. Judge Mel, I don't know if you saw this coming, but a third judge has now basically said, no, Lori, that's not going to happen. Your trial's underway.
Can I vote also and make it a fourth judge?
Oh, yeah.
It is. These are absolutely frivolous requests. She has as much chance of success as I do walking on the moon tonight. It's something you put up with when you have somebody with a questionable personality, a psychopath, defending herself. There occasionally could be a good argument that she could throw in, but for certainly she'll never find it. So, it's just part of the nuisance of putting up with somebody that thinks she's smart enough to represent herself. But I think the evidence they put together will have a verdict by tomorrow.
Yeah, I want to go to Rachel here. Let's talk about Nick Balance and why his testimony, even though it's hard to follow, and I was an expert on these kind of records and the data and the science of it, just talk about his importance.
Nick Balance's testimony is some of the most direct evidence involving Lori and Alex's participation in the crime. It's not just talk. It gives their location. It gives Alex's location. It is direct evidence of physical participation in acts that contributed to this conspiracy. And so I understand why a prosecutor would want to end on that. I always like to end with a more human element. I would agreed with Justin. I probably would have used Ray Hermosillo last, and maybe give him an opportunity to provide some color commentary to Nick Balance's testimony, to put it in context from an investigative point of view. But in terms of Nick Balance's testimony, it's physically where people were, or where their phones were. It's physically what was going on with phones. And that is the type of scientific evidence that the jury in this true crime loving, CSI loving world really latches onto.
Benjamin, she did not have one question for Ray Hermosillo. After 2 hours of testimony, she did not want to cross-examine. What were your thoughts?
I almost feel like Lori is waving the white flag right now and just giving up. I think you always have to at least have a couple of questions for the witness. This is show a defense, show a fight, because these jurors are watching her, and every time she's saying, no questions for multiple witnesses. So I'm thinking maybe her strategy is I'm not going to open the door. We talked about her opening the door to other bad evidence coming in. So maybe she wants to sit there and maybe she wants to save all her ammunition for an amazing closing argument, because that's what she's going to have to do. If she's not going to testify, it sounds like she's not going to testify. So she better do a great closing argument, because when you don't ask questions to one of the main witnesses, the jurors are just confused and like, why aren't you putting up a fight?
Rich Robertson, R3 Investigations. Are you surprised at the pace of this? Day 5, and we're about to see closing arguments this afternoon? You might be on mute, Rich. All good.
There I am.
There you are.
Yep. Didn't want the party in the background to.
It's all good.
We saw this in the Charles Vallow case as well, where things were just going along really quick because she frankly just isn't putting on a case, even in cross-examination. So how fast this thing went, the office pool here is going to be on how fast the jury comes back with a verdict. And so I think it'll go just as quickly as the rest of this trial has. She had a great opportunity, I thought, in this last witness. If she had had an expert and relied on that expert, they could have poked some holes in this thing. It wasn't that the evidence put these people in these locations, it put devices in front of them. That cell towers are not as precise as people like to think that they are. Just because there's records of communications going on between individuals, we don't know what the content of those communications were. So it seems like she missed a lot of opportunities to, I don't know that it would change anything in the end, but it would certainly have been a defense that should have been put on that any competent defense team would have done for her.
That's a good point, Rich, because on the surface, it's just phone calls. Yes, we know who the players are and we know who the alleged co-conspirators are, but we don't know what is the content of the phone calls. I was surprised that we didn't see any text messages, and throughout this whole trial, we did not get the revelation of why Brandon Boudreaux was a dark spirit, according to the inner circle. Rachel, this was the big, this was the bombshell in all of the other trials, is this belief system.
Yeah, I think when we saw Zulema and Mel Gibb drop off and none of the other sort of inner circle people were on the state's witness list, I was curious about that. It was very clear that the prosecution was working really hard to keep 404B out, was working really hard to not get accused of doing specific acts of misconduct. So when those people dropped off, I was curious about that, because there are, as we learned in Idaho and as we used in evidence in Idaho, there are communications with Zulema, with Lori and Alex. There are communications that the prosecution is choosing not to use. So to me, it shows how confident they are in the evidence they do have, and how far they're going to try to keep the 404B out and try it as a standalone case. So prosecutors have a lot of discretion, and they make choices on what they believe is in the best interest of the evidence they have. So I think the jury will see the story that's there, and I think we'll all be relieved that the jury convicted without the 404B or the cell phone.
Benjamin, let's talk Rule 20. Is this just protocol? Is this just a last-ditch effort since there's no evidence to be presented?
Yes, so let the viewers know what a Rule 20 is. After the state has rested and closed all their evidence, the defense is able to get up and pretty much ask for a dismissal of the case, saying that the state hasn't proven their case. As you already seen, Judge Boreski has pretty much alluded to, like, we're going to closing arguments. Let's talk about jury instructions. If Judge Boreski were like, let's not talk about jury instructions, I'm going to really take your Rule 20 seriously, they wouldn't even talk about jury instructions. So we already know that he's going to deny this motion after lunch, and they're going to go straight into closing arguments unless she changes her mind and decides to testify. But yes, it's one last ditch effort to make an argument to the judge to say that the state hasn't proven their case here and to throw out the whole case.
All right, Judge Mel, I'm sure you agree with that because that's true. He didn't even really, he basically ignored it. Lori's going to say there was not enough evidence, and we know what happened last time. So 120, we're going to hear this quick motion.
Yeah, it's going to be summarily denied. One of the things that has amazed me as you look at this case and the companion cases is how far and how much the criminal investigation science has improved. I went on the bench a half a century ago in 1974. There was no such thing as DNA. There weren't cell phones. I can't imagine kids today living back then without having a cell phone to work from. The science that we are able to put together has been absolutely magnificent. And I think it's plain in this case today, the way they're able to track movements by a phone and a tower, I think is compelling evidence. And law enforcement has much better tools today than they had over the last 50 years.
All right, let's take our poll question that now we've gotten the answer to. But for about 1,000 people voting earlier this morning, we asked, will Lori Daybell present any evidence on behalf of her defense? So all of you guys watching right now, 92% of you said she has none. So you were correct there, and I'm sure the panel agrees with you. 5% said yes, she'll call a witness or witnesses. 3% said she will take the stand. That's just that's a fantasy for a lot of people. Right, Rich?
Oh, yeah. She certainly indicated she wasn't going to take the stand. She didn't do it in either of her prior trials. So, why start now?
Yeah, I think everybody just wanted to see, well, why not? Let's just, for the last hurrah, let's bring on the Dave cam. Dave has got some questions for the experts. A lot of good questions from the chat box. Dave, what do we got?
This one is from Mabel Quintanilla. She says, can Miss K rebut if Lori cites Lori's love and kindness in her closing argument? Can that open the door to 404 or 405?
Who wants that one?
I'm happy to do it. Yeah. The challenge for Trina K will be if Lori does it in closing argument. I think she won't. It would be highly, highly unlikely that the judge would allow the state to reopen, offer evidence, and then just give a closing argument. The parties are not supposed to introduce new evidence during closing arguments that the jury hasn't heard. So likely what would happen is the judge would have an instruction, instruct the jury to disregard and admonish the defendant. So I don't think we'll see additional evidence interrupt closing argument. I'd love to hear what Judge Mel has to say, though.
My thought would be that she's got nothing to lose. If she's looking at that and her advisors are talking to her, taking the stand would have been a disaster. The prosecutor would have had a field day. But the fact of the matter is, she tried to personalize what a good person she was in her opening statement, and it was shut down. I really don't believe that she's not going to try that again. I think she will be shut down again. I think Trina will be jumping up. But she's produced no evidence. Some of the key witnesses, she didn't ask a single question. The only thing she's got left to do is to try to, by avoiding taking the stand in an argument, trying to say what a good person she is. It'll get shut down again. The objection will be sustained, but I think she will try.
Dave, what else do we got?
Good questions. This one from Jenny Allison. She says, I cannot wait to hear how the panel thinks the state did with laying out their case. Do you think it was enough and that the state proved her conspiracy beyond reasonable doubt?
Yes.
One word, yes, from Rich. Okay.
Rich was so eloquent.
Well, we were discussing this yesterday. Is this enough to prove a conspiracy? It doesn't mean that she had to be at the scene of the crime. We have not read any text messages, heard the contents of these phone calls, but it's clear that the storage unit video has to be something that the jury is still thinking about on their minds.
Yeah, I believe they have. I've thought all along that the evidence in this case with Brandon really sets forth Lori's role in the conspiracy. So my view is yes, as long as all the jurors were paying attention.
Benjamin?
I think if she had an attorney, I think this is the one case she actually had a chance to actually get maybe a hung jury. I don't know, not guilty, but at least a hung juror. She's not at the scene of the crime. You do see her, with Alex on the video and everything. However, as people listen to the jury instructions, she asked for what you call a mere presence instruction. That means just because somebody's at the scene of the crime doesn't mean that they actually did it. So I think if she had, competent counsel, I think this is the case that she actually could have maybe gotten a hung jury because she's not at the scene of the crime. Like we mentioned earlier, the cell phone evidence is kind of confusing. I think that can really confuse the jurors. And for a hung juror, all you need is one juror to be strong. And there's enough evidence here for a good defense attorney to poke a lot of holes here and say, hey, you have a lot of evidence here, but there's nothing that says that she actually conspired. Nothing on tape, no actual, video recordings or voice recordings. So I think there could be some doubt here if she had a competent defense attorney for this case.
Yeah. Brandon was my client, but I agree with Ben completely. This was the weakest of the cases. Looking at it from a defense perspective, there was so many opportunities here to question. I mean, the lack of motive is probably one of the things that's really important there. But the prosecution laid out a string of circumstantial evidence, and the story holds together. I think the jury is going to have no problem understanding the story. They'll fill in the little gaps of what those conversations were in their own minds, I'm sure. But they, all the movements and the timing and everything else, the story holds together, and they weren't given anything by Lori to shake that story.
I agree with you guys because in the last 2 days or so, what I heard as, if I put myself in the mind of a juror here, what I heard leaves so much to be explained when it comes to where is the conspiracy on Lori's behalf. And I know Trina mentioned it in her opening arguments about the religion, but obviously we never saw that. That was never presented in court. Right. And we Justin and I yesterday watching Hermosillo on the stand, there were times when we felt like a good defense counsel would have objected to some of the things that was said, or more so even in cross, had she taken the opportunity, we were surprised she didn't, to cross-examine Hermosillo with that very point of where am I in this equation? Where do you see me? Do you hear from me when there's a conspiracy? And then today when she crossed balance, and we have the bite where she kind of alludes to that, more so like, look, is it not uncommon for people to have multiple devices? And in your experience, she's questioning balance. In your experience, where does that put me? How do you know that the individual is with said device? So if they have two phones and a tablet, how do you know that person is with one of those phones or tablets? Same thing with Hermosillo yesterday when they're talking about Alex. Clearly he's a gun owner. They showed pictures of the weapons in his garage, but is it not uncommon for Americans to have weapons? Is it not uncommon for gun owners to search the web for gun-related specifics, where to shoot it? What is the bullet drop? I mean, it does seem extreme, but as Americans, we do this all the time. So there was opportunities where she could show the jury, look, yeah, they're telling you all this stuff, but this could mean a multitude of things. This doesn't mean that Alex drove to Phoenix and shot at Brandon, because at this point, they've proven that there's the Jeep that's been in Arizona at this time. This morning, they proved that the track phone was tracked in and around the area where Brandon was shot at, but they have no visual evidence of any kind showing Lori or Alex in Arizona on October 2nd. And there were moments where I feel like they missed this opportunity. And then I wonder if it resonated with the jury. So Ben, I'll ask you, is that enough on appeal? Could she throw it back at her legal counsel and say, my legal counsel failed to inform me that I could have done this or that to help my case?
Unfortunately, because she is now her own attorney and she's representing herself, she can't have anybody to blame but herself. And it's hard for the Court of Appeals to overturn anything that her advisory council says, because that's not how the law works here. When you represent yourself, you are the attorney and you are taking an oath to act like and know the rules of law. So there's really nothing that she can blame here. So she can probably try to file an appeal if she's trying to say that Judge Boreski didn't let in certain evidence that she wanted, or maybe let in too much evidence. You can always appeal on those grounds, but it's really tough to overturn an appeal once you have a jury verdict, unless there's some brand new evidence that we find that could have acquitted Lori that wasn't let in. So it's going to be very hard if she's found convicted, which she probably will be, to appeal this case since she's representing herself.
That wasn't bad cross by Obi. I think the chat is going to donate for you to get enrolled in law school. I think they're supporting you right there. I mean, but there are some points there, right? Like, why have we not seen text messages about the dark spirits? I think, is that something that makes things more hazy and confusing for a jury? Rachel, what do you think?
I think if you have the right witness, it does not. But it does create an issue that the appellate court will look at. Now, in Idaho and in the places where I practice, the law is really clear in terms of its admissibility. But a very conservative prosecutor will try to avoid using evidence that can create issues on appeal if they don't think they need it. So that is clearly a choice being made in Phoenix, that they want to make sure that they keep the case really clean. I do want to throw in a reminder on why she might have not have cross-examined Ray Hermosillo. Remember, she and Chad were calling Ray a dark spirit and actually named the demon that was inside of him. So, and he knows that. So, I think there's a degree to which Lori is probably intimidated by the breadth of Ray Hermosillo's knowledge about her and her background. And I think she avoided him because they've dealt with and seen him so much. I think Lori knew she couldn't touch him. But Ray could have talked about that. I think there's opportunities where some of that evidence could have come in. And so we're seeing a strategic decision to try a super conservative, clean case.
18 witnesses to none. Lori does not intend to call anyone. Mel, what do you foresee to be closing arguments for the so-called Doomsday Mom?
Yeah, my thought is that the prosecutor, Trina, looking at the history of this case, I think the Idaho cases are free. That's not going anywhere on appeal. She's going to lose. The first Arizona case with Vallow is the same. I think the strategic decision that was made in this case is that I will play it conservative. I'm not going to go with any of the 404B information. We've already got some guidance from Lori. She's probably going to represent herself. She's not going to put on evidence in her own behalf. And I think the circumstantial evidence is compelling. That storage unit and the tire and the timing and the calls, the burner phone, the location of the phone, her relationship with Melanie. there are a lot of pieces, and I've got to think the jury is wondering what in the world happened at the location where the Jeep was found. Everybody is close-lipped. Here, Brandon speaks out. It's Lori and her brother Alex that are the people that are the subjects. I think it's going to be a clear case of a conviction. It is the weakest of the cases that's laying there, but I think the evidence is sufficient that she's going to be convicted beyond a reasonable doubt. And I think it was strategically a safe play that Trina wanted to do to take away any argument on appeal.
Yeah, we have not seen a lot about the motive, the financial part of it all. I think that is something that we were expecting to see regarding, we know the life insurance beneficiary for Brandon Boudreaux is Melanie Pulowski, but she has not been named as she's being investigated but never been charged. So I guess you can't really go there. And as Lori had alluded to, she would not benefit directly. But if you really open the door, we know exactly how she intended to benefit through the Idaho case, through this, basically pot of money that would be shared through the inner circle when the world ended. Dave, what question do we have next?
We have a great question from E.C. Meister. This is for Rich or Rachel. Do we have any real reason why Brandon Boudreaux was targeted?
Rich, do you want to run with it?
Well, it's all part of clearing the decks. This small group of people were preparing for the apocalypse and bringing the flock together under Chad and Lori. Melanie was part of the flock, and those people who they did not perceive to be part of that group of either believers for whatever reason, either they rejected it. I think Brandon rejected getting involved in it, but the rest of them got all dark spirited. Tammy, the kids, Charles, Brandon, they were all targeted, and so they all had to be gotten rid of so that the rest of them could get together and become the leaders of whatever the new world was going to be. One that was much better than when Mel was taking notes with a quill pen.
I agree with Rich. And I had to chuckle at the dark spirited, and then you stop and think about what that really means. It's the similar pattern to what happened to Charles, to Tammy. That's what was coming next for Brandon. It's getting rid of that obstacle to building that life together, to building that future for the group. And so Brandon was Mel's obstacle and was a benefit. That group benefited financially from Mel's financial contributions. And so getting rid of Brandon candidly was just the next step in their overall plan.
And it may have, also, and that's a good point, because in life insurance, Charles Vallow had switched the life insurance beneficiary to his sister, unbeknownst to Lori. So once he was dead, suddenly that pot of money was no longer available for this cause. And so they were out looking for more money, and they got a little bit out of Tammy's death, a little bit out of the kids from a Social Security standpoint and that kind of thing. But they needed that big payday. So between July and October, they needed to come up with some money.
Yeah, Chad was taking people around, like David Warwick, etc., looking for property. So they needed money.
The question is, if Lori remained the life insurance beneficiary for Charles Vallow and she got $1 million, would they continue on, with the plan? I mean, I guess we'll never know, because obviously she wasn't the beneficiary. But yeah, both Brandon, Tammy, just like Charles, had sizable life insurance policies. Dave, we got one last question from the chat.
That is true. This is from Brittany Hennick. Why does the panel think the jury didn't ask very many questions?
Yeah. Good point. Not a lot of questions from jurors.
I think the jurors already know the issues here. There wasn't that much confusing. When I've done trials, when you know that the jurors are we're ready to go home. I mean, basically, let's take the vote right now in the jury box. I think these jurors are ready to go home. They've heard enough, and it sounds like if they were confused about an issue, they would write a question. The fact that they're not writing questions, it means that they must believe the prosecutor, or else they would be writing questions.
You know, there's a dynamic that we see with jurors and juries, even though they're not talking to each other necessarily. There's this groupthink that goes on, and occasionally you get a jury that thinks they're part of the investigation, and you start seeing a whole bunch of questions coming from them. Well, did you consider this theory? Did you collect that evidence? All that kind of stuff. This jury just seemed to be more like, okay, we're going to soak up what the story is. And it was a very clear presentation, so they didn't really have a lot to ask about. But you know, I think at the end of the day, that Ben's right. They're just going to go in there and say, hey, this is it all hang together.
All right, final thoughts on jury deliberations. How long do you guys think that this is going to take once the jury gets the case? Anyone?
I think we'll be done by tomorrow evening. If the jury begins deliberation today, there's a chance they would return, but my belief it'll be probably tomorrow. If they return in the morning, a verdict by 1 o'clock.
Okay, 1 o'clock. Mel, what's the verdict? What do you predict?
Oh, guilty.
Just had to check.
The way.
I think what'll happen is they'll go in there. It'll take them longer to select a jury foreman than it will be to convict, but they'll probably, in some of these, I've seen what happens. They pick the jury foreman, they take a straw vote, and then they say, and that'll be late this afternoon, and then they'll say, let's go home and sleep on it, make sure everybody's comfortable with their verdict when they return tomorrow. And that way they get another day's pay out of the deal too.
Good. That's a good strategy. I mean, and then you get some dinner, pick the foreman, talk about it a little bit, go home, then tomorrow get back to work.
Yeah, I agree with the judge. I think it's going to be tomorrow afternoon, likely. They're going to want to they're going to want to do their straw poll, but they really are conscious of people paying attention and not wanting to appear quick to judgment. So there'll be some review of evidence. There'll be some conversations, but I think we'll see a guilty verdict tomorrow afternoon.
Benjamin?
I mean, I agree it'll be a guilty verdict, but I think it depends on what time they get this case and how long is Trina Kay's closing argument and how long is Lori Daybbell's closing argument. If it's a pretty short closing argument and they get the case by 3 o'clock or even 3:30, I wouldn't be surprised if we have a verdict today. But they get the case closer to the end of the day, of course they're going to go home. But this is a pretty straightforward case, and a lot depends on what time they get the verdict. But I expect either this afternoon or early tomorrow morning, they're done. I mean, they might even take the verdict right there. Judge Boudreaux might say, raise your hands, right there, in there, and just count it, because I think it's been a pretty straightforward case here.
Okay, thank you to our experts. This is what we're going to do, though. Once the jury gets the case, I'm going to be in the group chat with you guys, making sure you guys going too far away, because once we're on verdict watch and we know they're not going home, we love to get you guys back on as soon as maybe this evening or tomorrow morning, as long as that jury is deliberating and not home. I think our chat and everyone watching would love to hear the insight, as we'll just, wait here for a little while together. So thank you guys again, and we'll see you soon.
Thank you.
Thank you.
All right, George, we're heading into it. The afternoon session in just a little bit. Roll 20 and then closings.
I'm still not 100% convinced the jury has been sold on this case. I think for two things. One, as we learned from the last jury, Lori's decision not to present a case weighed heavily on their decision. Which again would indicate that would, if the same rule applied, then they would have enough to convict her. But to me, that can go one way or the other with this case. But also too, like you said, you need one juror, right? You need one person in that jury box to go, I understand, that she didn't, that there were some things, that weren't on the up and up, but I'm not sure that there was enough that the state presented, if I'm that juror, that the state presented that would implicate Lori in any of this. And the phone calls back and forth and the storage video, I could see there being at least one juror that's still kind of on the fence. But whether or not that is whether or not that's the only factor, I think the jurors can see through a lot of this, and again, outside of the fact that Lori is representing herself, this defense has not done enough, and it's almost like they've let the state once again steamroll through this trial, and I think that may be at the end of the day, for a lot of these jurors, that could be the deciding factor. So we'll see. I think they'll take most of tomorrow. We'll see if they come back with any questions, if they come back with anything from the foreman that they want answered from either side. And then, of course, the gaps in all of this, right? The overlapping evidence where they have to be looking and going, all right, now who's Charles again? All right, they're married. I don't know really, why is he involved in this? Where Alex? Oh, Alex is dead? Oh, wow, well, that's weird. So, there's so many unknowns from their perspective because, again, they're not supposed to know all the other nuances. I would not be shocked if they came back as a hung jury or acquitted her, but I wouldn't be shocked if they, if it was unanimous because, again, they had enough to somehow implicate her in this conspiracy because this is a serious charge, and I think they know that. Again, if you take anything from the first jury, if you take anything from what those three jurors told us in the days after the trial was over, it's not unheard of to think that the same jury is thinking the same thing.
All right, we're underway in the courtroom in real time. We'll see you guys in a little bit.
All right, we're back on the record. State of Arizona versus Daybell, CR 2022-001242. The parties are present. Ms. Daybell, go ahead.
With a Rule 20, Your Honor?
Yeah.
Okay. The court must enter a judgment of acquittal on any offense charged in an indictment if there is no substantial evidence to support a conviction. Conspiracy to commit first-degree murder requires the state prove that I, one, agreed with another, in this case Alex, that one or more of us would engage in conduct that equaled first-degree murder, and two, that I intended to promote or assist in the conduct. The only evidence that has been presented simply establishes that I have been seen on video placing items into a storage unit. A phone that is connected to me through an email made phone calls during this time frame, and a Google search relating to Gilbert, Arizona. None of this evidence establishes that I agreed with Alex Cox to engage in conduct that equals first degree. The state has the burden of establishing all elements of an offense have been committed, and thus there is not substantial evidence to support a conviction.
All right. Does the state want to respond for the record?
Sure. Looking at the evidence in the light most favorable to the state, there is substantial evidence for a jury to find the defendant guilty of conspiring with Alex Cox to commit first-degree murder of Brandon Boudreaux. In this case, in determining if a conspiracy existed, the jury can look at the fact that the defendant went with Alex Cox to buy the burner phone, that she loaned her Jeep to him to be used, that she rented a storage unit, that she Googled how to remove the rear seat, that she hid the tire and seat, and that she created an alibi for her brother by having those two phones interact while he was in Gilbert, Arizona.
All right. The standard is whether a reasonable juror could find the defendant guilty, whether there's substantial evidence that a reasonable juror could find the defendant guilty. The state has presented a compelling case that Alex Cox traveled to Gilbert, Arizona, and attempted to kill Mr. Boudreaux. There's other circumstantial evidence that establishes that the defendant was aware of Mr. Cox's plans and facilitated those plans and assisted in those plans in several different ways. It's ordered denying the motion for Rule 20. Anything else? All right, just confirming that the defendant doesn't intend on testifying or calling any witnesses?
Correct. I would like to again just admit the letter from Tammy. It was marked.
Did we
Just
get it
wanted to
marked?
let you know that.
Okay, 203, for purposes of maintaining the record and any appeal issues, 203 would be admitted for the record, but not to the jury. Anything else? All right, let's bring the jurors in. I'll turn to the defendant when the jury sat, and the defendant presumably will say that she rests as well. Thank you.
And the jury is walking into the courtroom. You can hear that cough from Lori Daybell as she's about to officially arrest her case in front of the 15 jurors in the box. The state has already arrested, but they will go through the protocol here, and then jury instructions will be reviewed, read by Judge Boreski, and then closing arguments right after this portion. You saw the Rule 20 motion. Judge didn't consider it at all. There's definitely substantial evidence, at least for the jury, to take this case.
Seated. The defense has rested before lunch. I'll now turn to the state rested before lunch. I'll now turn to the defense.
The defense also rests, Your Honor.
All right, at this time, we are going to hand out the final jury instructions. My assistant will hand those to the jurors. Do the parties already have their copies?
Yes.
Okay. All right, it looks like all jurors have copies of the final jury instructions. Much like the preliminary instructions, you're free to follow along or just listen. I'm going to read these instructions as required. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You as jurors are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Admission of evidence in court is governed by rules of law. I've applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you in determining the facts. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and the defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before a trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant. The defendant's decision not to produce evidence is not evidence of guilt. Before you may convict the defendant of the charged crime, you must find that the state has proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. The crime of conspiracy to commit first-degree murder requires proof, 1, the defendant agreed with another with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of the other participants until it is established that a conspiracy existed and that person was one of its members. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means bodily movement. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of the jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. Make sure every member of the jury is present during the discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. In just a few minutes, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have any question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with the parties before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about the case until I accept your verdict. 12 of you must agree on a verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows. There is no significance to the order in which the options of guilty and not guilty are listed on the verdict form. At the back, this is the sample verdict form. You'll get an official verdict form from the clerk. But this is the sample verdict. Count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about October 2nd, 2019, as follows. Check only one, and the options are not guilty or guilty. The state can proceed with its closing argument. Trey, is the mic up there? We're going to put a mic up on the podium.
Who would want to kill you? That is a question that Officer Mary Ann Robb asked Brandon when she first arrived. That's a question that Detective Hiller asked Brandon when he spoke with him. Brandon Boudreaux gave the exact same answer to both of these officers. He gave them 2 names. Lori Vallow, the woman seated over here, and Alexander Cox. He told them that he believed his shooting had something to do with an incident that occurred in Chandler in July of 2019, a couple months before this. He pointed them to that. He told them that Lori Vallow had lived in Texas and that the Jeep used in this shooting was from Texas. And then he told them what happened. How he had come home that morning. This Jeep was parked unusually close to his driveway, waiting. That he noticed there was no tire on the back. That he noticed that Texas license plate. That it was a 2-door Wrangler, and then he noticed that window go up. He saw the rifle come out. He saw what he believed was a silencer at the end, And then he heard and saw that bullet that hit the frame of his car, shattering the window right near his ear, causing that loud bang that he heard when that struck right near his head, mere inches away from him. Brandon drove off and called 911, actually panting in panic from what he had just experienced. This defendant's co-conspirator also drove off to try to escape, immediately calling this defendant's soon-to-be husband, Chad Daybell, and Googling a way to get back to Idaho Falls, sort of through back roads. The names that Brandon Boudreaux gave the police were correct, but Brandon had no idea of the amount of planning that had gone on leading up to this October 2nd shooting. As you've seen and heard in this trial, much of this conspiracy, this planning, this premeditation occurred in Idaho. So what I'd like to do is go through the evidence, discuss it all together in a timeline that might make a little more sense than the presentation during trial, and show you how it all fits together. Show you how all of this evidence points to one conclusion, that this defendant was involved in that conspiracy to commit first-degree murder. Next, I'd like to talk to you about the jury instructions, go through some of them specifically, and then talk to you how this evidence proves beyond a reasonable doubt that this defendant is guilty. And finally, I want to talk to you about, I'll call them so-called defenses. Maybe that there was no shooting at all, perhaps Melanie did it, or maybe just that this defendant wasn't involved. And we'll discuss those options. So let's start with a timeline that you heard from the beginning of this trial starts around June 25th, when Brandon Boudreaux learns that this defendant has been feeding lies to his then wife, Melanie. She has been telling Melanie things like Brandon hacked into her computer, that Brandon was gay, that Brandon was trying to take her temple recommend away. Brandon told you that he had heard these things from Charles too, this defendant's husband at the time, who had told Brandon that his wife, Lori Vallow, was telling Brandon's wife lies. What did we learn from this? Brandon, in fact, texted Lori about this, told her, why are you spreading these lies about me? Why are you destroying my marriage? And as you learned, she didn't respond. Then you heard about that July 11th, 2019 incident in Chandler, Arizona. The one that Brandon, both to Officer Robb and to Detective Pillar, said, this has to do with this incident. What you learned from Detective Duncan, who came here, was that on July 11th, there was an incident. Lori Vallow was there. It was at her house, and Alex Cox was there. In her garage was that 2018 Jeep Wrangler with the Texas plates LWD 0997. And you learned that Alex Cox has his own vehicle. He doesn't need to borrow his sister's. He can drive his truck anywhere he wants. As Brandon's divorce is progressing, and he's seeking a mediator and working through that, this defendant and her brother moved to Rexburg, Idaho. You were provided with various documents from search warrants, both through Detective Duncan and Lieutenant Hermosillo, through lolly time iCloud accounts for this defendant, showing that she had emailed Blue Skies, that she rented an apartment up there. We see that she was searching for areas up there. We also saw that her brother, Alex Cox, moved right up there with her. Now, you heard from Brandon that part of their divorce Melanie moved into her own residence. And they put their community home up for sale. And on September 13th, when their home had sold, but it was still pending, he rented that house at 3875 East Phelps Street. He told just a handful of people that address. Melanie Boudreaux asked for it on September 17th, and he provided it to her. Why wouldn't he? The only other people who knew that address were his 2 neighbors and a couple of friends, 5 people. But the only one that knew this defendant and Alex Cox, the woman that she referred to as her mom, that was her mom figure, this defendant, Lori Vallow, is the only one that would have known that address so that Alex could go there later. We know that on September 25th, Brandon moved into that residence. And he moved in early because his then soon-to-be ex-wife was leaving out of town. We know in the same time period, Melanie knows the address. The plan is already starting. Alex is searching for places to shoot. He is also looking for tent shops. Not a tent shop for his Ford F-150, because if you lay in the back of the truck, of course all the neighbors can see you. He is going to borrow this defendant, his sister's Jeep, Melanie Boudreaux's mom. And so he finds a place that will tint that Jeep as dark as possible, so that even in the daylight, no one can see into the back, so he can lie in wait. We saw that not only does Alex search for and get to Dan's windows, and this is important. You may say, well, who cares? Of course we know that. We heard from Dan Moss. But when you start thinking about the other searches to these Gmail accounts and you want to authenticate them, you know that these are legit. Why? Because here's Alex searching how to get to Dan's, and then what does he do? He shows up there with this defendant's Jeep so that it can be tinted. What do we know? We know again from Dan that they spent $200. They're in Idaho. This Jeep is already tinted. Why would you ever put additional tint on that Jeep? It's not even your primary car. We see Lori Vallow driving her little Nissan Rogue all over the place because you need a vehicle that you can hide in the back of and that you can shoot out that back window from. The burner phone. We heard this morning from Nick Balance, and he talked to you about both the records that you have seen that were admitted, as well as now the Google location data and cell phone analysis. What do we know? That on September 25th, when that burner phone was purchased at that Walmart, Alex Cox's phone is there, and Lori Vallow's phone is using a cell tower in that area. They drive out of town to a different Walmart to go buy this phone. Lori Vallow doesn't live in Idaho Falls. She lives in Rexburg, but her phone is in Idaho Falls talking with Melanie Boudreaux. What do we know the next day? Alex Cox activates that burner phone. That burner phone is only going to be used for one trip. The trip to Gilbert, Arizona and back. This is what you learned from Nick Balance this morning. That again, Alex Cox's phone tied to that Google account is showing right there in the Walmart. This defendant's phone is also in Idaho Falls, utilizing a tower at that Walmart. Then we know on the 26th, when we're activating this phone, Melanie Boudreaux flies up here to be with the defendant. We know at this time, Brandon Boudreaux has the kids, and we know that they have an agreement. Brandon will keep them Monday and Tuesday and Wednesday. Wednesday, October 2nd, he will hand them back to her, and they will stay with her. So when he's shot and killed, it won't matter because she'll have the kids. It'll be fine. They know, because it's the plan, that their youngest gets dropped off every morning. Brandon will pull up to the park and let her know he's there. And so all of this information is known. Now, how do we know it's known? We know by the timing. And so we'll go through that. But remember, this is when Melanie's coming up and spending 3 days with this defendant. She has to be back Monday. Why? Because she's going to take the kids like she always does. Again, we have Alex Cox preparing for this shooting. We know he's not only practicing, but he's trying to figure out trajectory. What do we know? That this is a moving car. Alex Cox is going to have to try to fire out the back of a Jeep at a moving car. And ladies and gentlemen, he came pretty close to being successful at that. We know that Melanie flies back to Arizona. And then we have the beginning of the trip. And the beginning of this defendant starting the giant alibi defense that she does. Why would anyone ever take someone's cell phone and carry it around with them? Why would you take someone's cell phone and do that? Why would you make phone calls between each other other than to ensure that it looks like Alex Cox is still in Idaho? They think he has a burner phone. No one will even know. Great idea, other than we know he hooked it up to his Google account. So we know that the afternoon of the 30th, Alex takes his phone over to his sister's apartment. And it stays there or with this defendant until he returns on the 3rd. We know that at about 5:15, Lori Vallow searches how to remove the back seat of the Jeep. Alex Cox still is there, and now she is helping him get ready for his trip. She has his phone, she's giving him her Jeep, and she is helping him make it more comfortable so he can lie in wait in the back. They had to remove the tire, and they had to remove that back seat. We know that sometime that evening, Alex Cox leaves Idaho and moves towards Gilbert. We heard from Detective Pillar that there was an LPR reading for that Texas license plate LWD 0997 at around 8:10 outside of Rexburg, Idaho. We know from the balance that there is no phone activity until we see the phone arrive in Arizona. We also know that the Jeep is in Arizona. So we have the burner phone and the Jeep, and Alex Cox is Googling in Arizona. Holbrook, we see that LPR reader showing the Jeep with no tire on the back, so they can open that rear window exactly as Brandon explained. This defendant's Jeep. What do we know is that, again, the burner phone is calling one person, this defendant's husband, Chad Daybell. We see that Alex Cox is in Arizona with other physical evidence. What is that? It's that receipt from Los Favoritos that was recovered inside the Jeep in Idaho. So we know the Jeep is down here. As much as the defendant wants to tell you about colors or whatever else, her Jeep was here in Mesa on October 1st of 2019. We can just stop pretending that didn't happen. We know as well, when we look at those Google records, and we're trying to authenticate them, that the Los Favoritos was on Power Road in Mesa, and after having lunch, Alex Cox Googled another location on Power Road. Now, this defendant, in aiding this conspiracy and helping her brother, starts by renting that storage unit. Now, she rents that on October 1st. She also still is in possession of her brother's phone. So this way it looks like Alex Cox is going with her to the storage unit. She's providing that alibi because they don't think that the burner phone has hooked into this Google account. They don't know about the LPR readers. They don't think about the receipt. So Lori Vallow provides his alibi and she brings the phone with her, and we know that Alex Cox's phone is with this defendant as she's renting a storage unit. Even though we know from the video, he's not there. She's alone. When you watch these videos, and if you want to, they're obviously admitted, you will see one person get in and out of that car, and one person go into the storage unit. That one person is this defendant, Lori Vallow. So even though Alex Cox's phone is here, that's just a ruse. That's her aiding, that's her conspiring, that's her trying to cover up this murder for her brother, who is the shooter. What we know as well is by October 1st, we know the Jeep and Alex Cox are here in Arizona. And we know that that evening of October 1st, he Googles that address. The address that only 5 people knew. The address that this defendant's niece, the person she said she is like a mom for, that's where her ex-husband, or soon-to-be ex-husband, is living. He Googles 3875 East Phelps Street, even with the zip code into it. And then he gets directions there, getting prepared, knowing where he needs to go the next morning. Why? Because again, Melanie and Brandon have a very set schedule, and they know that Brandon's going to drop off the kids and then meet Melanie to pass off their youngest, and Alex will be waiting at home. We know the next morning, Alex Cox Googles again the address for Brandon's home. We know that that morning, Alex Cox's burner phone is utilizing towers near this defendant's niece, Brandon Boudreaux's soon-to-be ex-wife's home, Melanie Boudreaux. And we know that the calls that he is having are with this defendant's husband, Chad Daybell. And we know that by 7:22, Alex is moving towards Brandon's home. He knows that Brandon is going to be leaving to take the kids to school because Melanie knows the schedule, and he will be waiting when the kids are dropped off. The morning of October 2nd, Brandon has a very normal schedule. He's got to get his kids to school. He leaves around 7:25. He drops off his first kids at school, and then he meets with Melanie and drops off their youngest. Melanie does not know that Brandon is going to work out. Normally, he'd go home. Alex would be waiting there. But instead, he went to the gym. Now again, we've heard a lot of questioning of whether or not a Jeep existed there or not, but we all know that it's this defendant's Jeep. But we also know that a neighbor across the street saw the Jeep there, and not only saw it, but knew something was wrong. He told you that it was parked on the wrong side of the road, nose to nose with that white van, that it was running, that it had really dark tint. And in fact, he told you he was so thinking it was out of place that he actually looked in his rearview mirror to try to just see what the license plate was, and he noted it was a Texas license plate. He told you it was just a dark Jeep, whatever color that is. And we know at this time period again, this defendant's co-conspirator's burner phone is still calling one person, and that is Chad Daybell, this defendant's husband. Now, we know that this defendant has been carrying around Alex Cox's phone, the phone subscribed to him, the one that if you looked at, you'd be like, oh, there's where Alex Cox is. Look at that Wi-Fi. She's been carrying it around, and now she knows if at 7:40 there's going to be a handoff of the kids, we need to make the alibi, 8 o'clock. And so at 8:02 Arizona time, she has Alex Cox's phone call her phone, and there's a fake 24-minute call. Look, Alex couldn't have done that. He's up here in Idaho with me. Of course, Brandon was at the gym, so it's a little early. But still, it's an alibi. Can't have run down to Arizona in those next 40 or so minutes. So we know, of course, that while that fake call is going on, the Idaho Falls burner phone is in Gilbert, utilizing cell towers that are in the area of 3875 East Phelps, and Lori Vallow's Jeep is parked right outside of Brandon's house, waiting for him to return home. We know that 20 minutes before Alex Cox shoots at Brandon, Lori Vallow's phone gets a call from Melanie Boudreaux. Here they are, still talking and conspiring, trying to figure out what's going on. Where is Brandon? Brandon returns home about 9:13. Alex Cox has been waiting there now for almost 2 hours. He returns home and sees that Jeep. And just like Robert Abitamarco, he notices it being parked really close to his driveway, and it stands out to him. And of course, then he sees that window open and that barrel come out, and this gun shoot at him and almost hit him. We know from Lynette Mendoza, who had a Ring camera, that just a few seconds before that shooting, her Ring camera had shown a black car, and you just see a bleep of it in the beginning as it kind of jumps, go by that corner. And then a few seconds later, you hear that loud bang. When you look at the time on that Ring camera that you have admitted, it matches up with that 911 call, with when Brandon is calling in to say he's just been shot at. Like Brandon said, loud. You've heard a lot about the color of this Jeep. Even when we look at photos of the exact same Jeep here, they all look a little different. You have the DEA one that looks almost silver, brown, I don't know. You have an upper one from Chandler that looks a different gray with a dark gray, and then you have the one from Dan Moss that looks more greeny colored. What do we all know? They all have the same license plate on them. They're all this defendant's Jeep. So when we're talking about color, that's just everyone's perspective. What do we know in actuality? That Brandon's Tesla was shot by a large round that it hit the corner of that glass that went up into the frame of his vehicle, that it left a divot in the glass, and that somehow the police, in trying to search a giant block radius, were not able to recover those pieces of the projectile. We only have a few fragments of it. But everyone who has worked these scenes knows that's a bullet hole, and those were projectile fragments. And that was a gun that Brandon saw, and that's a shot that he heard. Immediately after hitting Brandon, Alex Cox takes off and is searching for directions out of there. And you saw those, and you saw a map as he went east, and those matched with the cell phone and cell tower records that Nick Balance told you about. Brandon is on the phone with 911. Alex Cox is fleeing because he knows Brandon's alive. We know that the other part is that while this is going on, while Alex is searching for his way home and has been talking to Chad Daybell, knowing now that Brandon's alive, what do? They go hide the tire and hide the seat. So the timing of those videos when Chad Daybell, person who is talking to Alex Cox, and this defendant go to the storage unit is as Alex Cox is calling him and telling him whatever as he's fleeing to go home. So we know that they arrive there, and you can watch these. By they, I mean Chad Daybell and Lori Vallow. And we know that they bring in a tire and what looks like a seat. You can actually see Chad rolling the tire in. And again, why is this important? This is this defendant who has helped take the tire and seat out of her Jeep to make it available for her brother to take his guns down to Arizona to shoot at her niece's soon-to-be ex-husband. That's what we're talking about when we're talking about this conspiracy. As time goes on after the shooting, we know that, again, that burner phone and that Jeep are returning back to Idaho. In fact, Alex Googles all the way to Idaho Falls Airport. He knows how to get home from there. While he's doing that, again, we're having the storage unit. What do we know as the Jeep is coming back? It's back in Idaho and around Rexburg around the time of 3:54 and 4:28 when LPR readers note the Jeep back up there. What do both this defendant and Alex Cox do? They're both searching, trying to get the news. Brandon shot? Did he die? Did he live? What happened? Do they have leads? And again, when we talk about the Jeep and this idea that somehow it's not this defendant's Jeep, that she wasn't involved in this, we know that there was gunshot residue, characteristic particles that are unique to just gunshot residue located in the back of this Jeep, not on the seat or the floor, but on the windows. Why? Because when a gun is shot inside of a car, that dust goes everywhere. And that's why they were able to collect that. But do we know that even though this is the defendant's Jeep, Alex Cox's DNA is on it? So let's talk about the jury instructions. I want to go through a few of them in specifics and then talk to you about the charges. Burden of proof. The state has the burden of proof, as we should. and we always will. You're told that the burden of proof is proof beyond a reasonable doubt. And you're told that proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. That there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. When we talk about reasonable doubt and that burden of proof, I want to start with what it isn't. Proof beyond a reasonable doubt is not proof beyond all doubt. It's not proof beyond all possible doubt. It's proof beyond any reasonable doubt. And I'll give an example. When Kyle Mueller was on the stand and he was questioned about gunshot residue, he was asked, for instance, if a bunch of hairspray could cause the GSR in the car. And he said, well, maybe like one of the particles, but not all three. So maybe if all they had found, possibly you could say that was a doubt, but is it a reasonable doubt that hairspray caused the GSR in the car? No. So let's talk about direct and circumstantial evidence. And that's because we have a mixture of both here. So direct evidence is evidence that a witness saw, heard, or otherwise sensed an event. What Brandon told you about that happened that day. What Robert Abotamarku told you about. That's direct evidence. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. And you're told the law makes no difference between direct and circumstantial evidence. So I'm going to give you an example here as well so that we can understand what you can do with circumstantial evidence and why it is so important. Assume you are seated on a beach and it's in a cove and you can see on each side you lose sight of people. While you're sitting there, you're the only person on the beach, there's no footsteps there, and you see a person come from your left, walk in front of you and go to your right. They go around a corner, you lose sight of them. A couple minutes later, someone comes in and says, hey, did you see anyone come by? And you say, yeah, they just went that way. That is direct evidence. You saw it. Now imagine you're on that same beach, same situation. Sand is smooth, you close your eyes for 5 minutes. When you open them, you see footsteps now on the beach. You can see the toes and the heel. So you can see the direction as it crossed again from your left to your right, but you don't see a person at all there. You know your eyes have been closed for about 5 minutes. Someone comes up and says, hey, has anyone gone by? And you go, yeah, I mean, in the last 5 minutes, someone went that way. That is called circumstantial evidence, and you are able to infer from that that someone went by. So let's talk about the crime. The conspiracy to commit first-degree murder requires that the defendant on or about October 2nd, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct that constituted first-degree murder. I'm going to go through a few things, then I'm going to talk about them all together, because these jury instructions really have to be considered as one. So conspiracy. When we're talking about conspiracy, we're talking about the defendant agreeing with Alex Cox and others to engage in that conduct, first-degree murder. That she had to intend to promote or assist, and that's going to be very important here, in the commission of that conduct. She doesn't have to be the shooter, she has to promote or assist it. And that the intended conduct would constitute the crime of first-degree murder. Again, doesn't have to be completed. That's why it's conspiracy to commit first-degree murder. Proof of the membership. You're told that one may become a member of a conspiracy without knowing every detail. She doesn't have to know how long Alex is waiting there, what type of bullets he's going to use. The evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other persons participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. In determining whether a conspiracy exists, you should consider the actions and statements of all of the alleged participants. So you're going to have to look at everything and look at what this defendant did to promote or assist that conspiracy. So, first-degree murder. Again, I'm going to just note that conspiracy means the parties agreed to engage in that conduct, so it doesn't mean there has to be a death. They are conspiring to kill someone. So we know that someone shot at Brandon Boudreaux and came very close to causing his death. They have to intend or knew that he or she would cause the death of another person, which when you are shooting at them with a rifle, that is what you are intending or knowing, and they acted with premeditation. Talk about premeditation and then we'll wrap it all together to discuss. So, premeditation means that they intended to kill another person and that they formed an intent or knowledge and then reflected on it. Now, in Arizona, premeditation does not require some long, drawn-out plan. Reflection can be very fast. But in this case, we have premeditation that is days and weeks before this. We're talking about September 23rd, 24th, 25th, all the way through up to October 2nd. So this premeditation is above and beyond what is required by the law. This defendant started helping when they went to buy that burner phone, when she loaned her Jeep to allow it to be tinted, when she Googled how to remove that rear seat, and they took off the tire, and she kept it with her. Then she rented a storage unit and put it in there. When she kept her brother's cell phone and kept it with her as she went around Idaho, and when she made that call between those two phones, right around the time of when the shooting was supposed to occur. That is the aiding and the promoting done by this defendant. That is her acts. That is the conspiracy. But again, you look at all of the evidence to see how does that fit in. It's not just someone holding someone's phone. If that were it, sure, we might wonder what's going on. But you can't look at these facts simple and separate. You have to look at the actions of everyone and see how that fits in with all the evidence in this case. This defendant didn't just go buy a phone at Walmart and that was that. This defendant didn't just rent a storage unit and put her own personal property in there. This defendant didn't just decide to loan her Jeep to her brother and then decide to take the rear tire off it and the interior seat out of it. She did all of these things to aid and promote this first-degree murder. When we're talking about defenses in this case, there are potential ones we'll talk about. You've heard in this trial that maybe there was no shooting. There's not even a first-degree murder because I believe there were some thoughts about that the hole in his car was made by a tire iron or whatever other defenses there were. But what do we know? Yes, there's a shooting here. Brandon's car has a bullet hole in it. There are fragments from that bullet hole in there. There's damage to his glass consistent with that location of the bullet hole in his car. Brandon called 911 out of breath from the fear of having just been shot when that bullet hit the frame of his car right near his head and shattered that window next to him. the Ring camera and that gunshot that you heard. Robert Abitamarco putting the Jeep there is idling there. So, is that a defense? No. There was a shooting. So what else? We've heard something about Melanie doing it. She had a financial motive. And I'm not here to tell you that Melanie wasn't involved in this. I'm telling you that this defendant was also involved in this. When we talk about a conspiracy to commit murder, there can be multiple people involved in that conspiracy. There were multiple people involved in that conspiracy. Melanie Boudreaux is the only one that had the address. So, yes, she was involved. But was she it? No. This defendant helped ensure that her brother could help Melanie by killing off her soon-to-be ex-husband, by loaning him the Jeep, by helping make the Jeep available and accessible to fire out of, removing that rear tire, removing the seat, allowing him to put the dark tint on it, and taking it with him. And then providing that alibi over those days while he was gone to help cover up that he was the shooter. I think she also said maybe she's not responsible for what her brother has done. But we know she is responsible. She is a co-conspirator. She is assisting, she is promoting in this crime. We know from the 25th on, she is helping to get the phone, to get ready, to make the Jeep ready, to cover up for her brother, to hide those extra parts, to Google how to even get the Jeep ready, and eventually also trying to figure out what went wrong so they could then determine what to do after. Brandon Boudreaux knew who was involved. He may not have seen who did this. The defendant has tried to explain away the evidence and questioning witnesses, asking if it's possible for a single piece of evidence to mean something other than what everyone knows it means. Is it possible that a Coke bottle broke in the street and one little shard stayed there right where Brandon Boudreaux's Tesla was located when it was shot? A shard that looks just like the glass from his car in the driveway inside the seats. Is it possible that a tire iron made that bullet hole in the Tesla? Is it possible that the GSR in the Jeep is hairspray and fireworks? Is it possible that a Jeep with Texas plates belonged to someone else who wanted to kill Brandon? Is it possible that Alex was in Idaho and called her on October 2nd at 8:02 for those 24 minutes? Don't fall for the defendant's questions about what is possible when the evidence shows exactly what occurred. The only explanation when we look at all of the evidence together is that this defendant conspired with her brother and others to try to kill Brandon Boudreaux. The state asks you to look at all of the evidence, not just the is it possibles, and find the defendant guilty of conspiracy to commit first-degree murder. Thank you.
All right, the defense can give its closing argument.
When a family breaks apart, it is a tragedy, with the devastation far-reaching, affecting many people. I am not exempt from tragedy, none of us are. But what we learn from it is most important. Because of this experience, I've studied the law and the judicial system, and that knowledge will stay with me forever. When we experience tragedy, we can grow stronger from the experiences, and then those experiences are not all negative. You would think that often people in my position would feel defensive or angry, and from where I am standing, I understand that very well. But I don't feel any of those things. You have watched me under pressure, under scrutiny, and even under attack. And I have shown you that I'm not on any of those things.
I'm going to object to character evidence and testimony that's not in
Sustained.
evidence.
Ms. Daybell, could I have you pull that microphone a little closer, please?
You can't be upset with people who are forced to look at your life from a distance or judge it through a lens that's being intentionally distorted or being at least very limited. Like the lens the state has shown you on this event. There's so much more going on that is not included to your view. The law prevents some of these things from being shared
I'm
in
going to
trial.
object, Your Honor, to improper.
Sustained.
You have seen opinions formed by strangers trying to put together a narrative. I have shown you that basically there is no defense to what a person did not do or did not participate in. Other than what you've seen, which is no evidence that I made an agreement to commit a crime, because no such evidence exists. So I'm not defensive, I'm not angry. Nobody has all the pieces to this puzzle. It is complex. Like most families, this is a complex issue. And like the state, I was not there. But there is no agreement, no plan, no game. I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreaux decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right, the jury is reminded that what is said in closing statements or closing arguments is not evidence, it is not testimony. The intent of the closing argument is for each side to argue what the evidence shows. Go ahead.
I did and have supported my niece Melanie when she suffered tragedy as a young child and during this terribly difficult time in 2019. We read the text from Brandon to me on June 25th, 2019, where he claims that he will never stop until he proves that I am responsible. Well, here we are, almost 6 years later, and I'm charged with conspiracy to commit first-degree murder. In order to have a conspiracy, 2 or more people have to make an agreement to commit a crime. There is no such agreement between me and my brother Alex, although I did love my brother Alex.
And I'm going to object again, Your Honor, to testifying.
Sustained.
There is no agreement that was shown to you between myself and Melanie Boudreaux, although I love Melanie.
And I'm going to object again to testifying.
Sustained.
I cannot tell you what happened that day on October 2nd, 2019, because I was not there.
And I'm going to again object to testifying, and please strike everything the defendant has said.
All right. The defendant is admonished, you cannot argue things that were not admitted into evidence.
The prosecutor wasn't there. Law enforcement wasn't there. Only Brandon knows what happened before he called 911. Only Brandon said he will not stop. The fact that I supported Melanie in her time of need does not make me against Brandon. I had nothing to gain by Brandon being hurt. Brandon has worked with law enforcement for almost 6 years to make sure that I pay a consequence.
I'm going to object to misstating the evidence.
Sustained. The jury will determine what the evidence did and did not show.
Your job is to determine if I committed a crime, this crime, a conspiracy, an agreement, not cleaning out a garage, but an agreement to commit murder. You did not see an agreement. You did not hear an agreement. You heard Detective Duncan say that he had spent hundreds of hours going over my iCloud accounts. They have 19 years of my accounts, text messages,
And I'm going to object to
calls.
misstates the evidence and no.
If there was an agreement.
Hold on. The objection sustained. The jury is reminded that they will determine what the evidence did and did not show. Go ahead.
If there was an agreement, they would have showed it to you. There is no agreement. We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought.
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
Because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing. Thank you.
State wish to give a rebuttal, please.
Thank you.
All right, the state has the burden to prove the defendant guilty, and since they have that burden, they have the right to open and close the argument. Go ahead.
The defendant wants you to think that Brandon has it out for her. She has tried to insinuate that Brandon was involved with working with Detective Pillar for years just to get her. But what you heard was that Brandon has actually been working with law enforcement on multiple investigations, and that in fact Melanie Boudreaux is a subject of multiple investigations. So again, as the defendant sits up here and tries to portray and paint a picture for you of her innocence and sadness and family tragedy, she again misrepresents what was told to you at trial. She tells you there was no plan, but she ignores the facts and the evidence of a very obvious long plan. A plan that started when she began, this defendant, Lori Vallow, meddling in Melanie and Brandon's marriage. And when that marriage was finally ending, this defendant continued to help her niece, Melanie. She continued to aid her. And what we see in every one of these bits of evidence is a core group of people. This defendant, her brother Alex, Melanie Boudreaux, and Chad Daybell. The four of them working together. Do we need to have words, a video? No, we do not. That is why there is that jury instruction on direct and circumstantial evidence, because you look at what is going on here, and it screams to you a conspiracy by this defendant, by Melanie Boudreaux, by Alex Cox, and by Chad Daybell to kill Brandon Boudreaux. Every action you see there, the defendant would like you to look at them individually and pretend that they don't all point to what happened on October 2nd. But everything they did leading up to then shows you a way to cover up and prepare for the murder of Brandon Boudreaux. When we talk about a plan and this defendant's actions, the most obvious and screaming piece of information is this defendant holding on to her brother's phone for days, holding on to the 480 351-9120 number for days while her brother is gone with her Jeep, without the rear tire, without the back seat, with a gun with him. That is part of the plan. That is the assisting, that is the promoting, that is the conspiracy that this defendant wants you to pretend doesn't exist. We don't need words. We have actions that are obvious, and they're done by this defendant and her co-conspirators. The state asks you to look at everything together, regardless of how many people want to cry up here, regardless of how many people want to try to testify. This is not evidence. What is evidence is what was presented to you in trial, and each piece of that tells you this defendant is guilty. And so I ask you to find her guilty of the conspiracy to commit murder against Brandon Boudreaux. Thank you.
All right, members of the jury, the case is going to be submitted to you shortly, but first we're going to draw our alternate jurors. Again, we have extra jurors just in case someone becomes sick or is unable to proceed. So we're going to call 3 alternate jurors. If you are an alternate juror, it may be disappointing to get to this stage in the trial and not be in the deliberation process, but I have in the past had to call back an alternate juror to come back in the jury room when a juror is unable to proceed. So the admonition would still apply to you until we call you and let you know that you're excused. If I don't see you again as far as an alternate, I want to thank you for participating in this process. We couldn't have done it without you. Now we're going to use our very scientific method and draw numbers out of a hat here. Juror 3, you're our first alternate. We're going to draw another.
16.
16. Okay, and
7.
jurors 3, 7, and 16. 7. Okay. I'll come back and talk to you in a few moments before you go, but please, the admonition still applies. I have had to call alternates back. Again, I thank you for your service in this matter. We're going to swear in my staff, the staff that I have so far. My Jay is on vacation this week, so go ahead.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God? I do.
All right. The jury is excused at this time to begin their deliberations.
All right, jury.
All right, please be seated. The jury is no longer present. I'm going to put everyone on notice that it would be the court's intent to take a verdict within about 20 to 25 minutes of being notified that the jury has a verdict. So if you want to be present for that verdict, I would advise everyone to stay within about 20 minutes of the courthouse. In other words, in the immediate downtown area. The state has filed an allegation of aggravating circumstances back in January of 2024. One of those aggravators is essentially kind of an overlap with a finding of dangerousness. What other aggravators would the state intend on proceeding with if there were a guilty verdict?
Your Honor, we could just prove the dangerous allegation and accomplice. That would be sufficient.
Okay. Last time we discussed this issue, the defendant was requesting a probable cause hearing, but also indicated that she didn't want to have an aggravating factors hearing. So let me ask the defendant, last time you admitted aggravators, I don't know what your intent is on this time around.
I would object to the aggravating. Of course, I would object to it. I asked for a 13.5 hearing on it so that those aggravators could have probable cause. If you're going to go forward with them, then I will stipulate to them.
All right. Well, the court, I don't think you're entitled to a probable cause hearing, but based on the evidence that was admitted, the court would find that there's probable cause been established that this was a dangerous offense and that there was the presence of an accomplice. I'll go ahead and prepare the instructions just in case, and then we'll see what the jury does. Please make sure that my assistant has the necessary contact information for everyone. But again, I would ask people to stay within 20 minutes of the courthouse. All right, thank you.
And you are looking at the end of a 5-day, well, I shouldn't say the end of a 5-day trial, but the end of the presentation of this case, the end of closing arguments, the jury getting the case, the final 12, and you may have just seen Brandon Boudreaux hug Kay Woodcock. They have been through so much together. You know, Brandon is relieved to get his day in court. Lori Daybell not providing any evidence, not presenting any evidence, not testifying on her own behalf. And now we have a jury of 12. Now, by my notes, it is 7 women and 5 men. Remember, we started with 16. We had a juror excused really before opening statements. It was a male that was excused. So you had the 8 and the 7 as far as women to men. And then after this randomizer of choosing the alternates, 3 were chosen as alternates. 2 of them were men, 1 woman. They could be called on if anything happens. Is now jury deliberation went on for about 15 to 17 minutes. We were clocking that as they entered the deliberation room. They may not even have really gone over anything at all and just decided, okay, who is our 4-person? Do we want to stay here this afternoon into the evening and get this done, or do we want to come back tomorrow refreshed? They ultimately decided that they were going to go home for the day, come back tomorrow at 10 in the morning. So we will be, continuing that clock for Verdict Watch tomorrow morning. We will be streaming right here from Fox 10 Studios for coverage of the Doomsday Murder Trial, the final chapter. But you heard closing arguments there, very short from Lori. She got emotional, whether you buy it or not. She said that she did not make an agreement with her brother, Alex Cox, at all, and that this was not a conspiracy. She once again calls this a family tragedy. She goes back to the date of June 25th, 2019, saying that at that time, Brandon was going to prove to everyone that she was responsible for the ending of his marriage with Melanie Boudreaux because of the misinformation that had come out to his wife at the time, that he had hacked Lori's computer, that he was gay, multiple things that were just not sitting right with the family, very much a family drama. She gets emotional then, saying, she's sorry he feels this way. There were so many objections that we heard by the state, objecting to her talking about character evidence, appearing to testify through her closing arguments. We have seen this pattern before. She did not have any witnesses to call. She's not going to put herself on the stand and open herself up to cross-exam by Trina Kay. So this is really the last-ditch Hail Mary. Trina Kay did do a very thorough job of presenting this PowerPoint, going for almost an hour and listing everything that Lori has done in this timeline that promotes and aids a conspiracy. whether she knew what Alex Cox, her brother, was going to do that day. It is the burner phones that were being purchased. It is the storage unit where the tire in the back seat is stored. It is the calls that were made after Alex drove off out of that neighborhood after Brandon Boudreaux was shot at, after he allegedly opened fire on him as he arrived in his driveway in Gilbert on October 2nd, 2019. So what do you all think? You have all been watching this entire case closely in this trial. Was there enough for the state to prove that there is a conspiracy to commit murder? Now, just 15 to 20 minutes ago, whatever it was, I called the court spokesperson and he told me they're coming back tomorrow morning. I almost had to double take and say, wait a minute, they're coming back tomorrow, or is a verdict in? That would be so unbelievable and hard to believe, to fathom that a verdict was in that fast. But he reconfirmed, yeah, they're going home for the day. After hearing all of that testimony, especially from Nick Balance, it gets very technical regarding cell phone data, and then going through some long closing arguments, specifically from Trina K. It's like you're hearing the case all over again in order chronologically, and how the state is trying to make sure that the jury instructions are understood. The judge also going over the jury instructions. So it has been a long day. It really has only been 5 days of trial. And I think, the jury says, well, we are doing our duty. We get paid for our duty as well. There's no need to rush this. This is definitely a serious case. Let's go home. Let's get refreshed, recharged, and tomorrow morning we'll get back to it at 10 a.m. Meanwhile, we're getting ready for our coverage of this case that goes on our newscast as well. We have nearly 2,000 of you watching, looking out for questions. The chat box is blowing up here. George is working on producing our shows as well, juggling multiple tasks. How are we looking? And I guess since you're going through all this sound, there's got to be sound bites that are standing out to you that we're going to be using later on.
Well, I will say what I'm noticing is as we were following the closing arguments, kind of a stark contrast from what we saw earlier in the morning. A lot of technical, stuff, a lot of, a lot of graphs, a lot of maps, a lot of data being thrown at the jury. Then you flip the script. Trina K comes out with her closing arguments and really kind of hammers home the conspiracy part at the end of all of this. And then in her rebuttal to the closing argument from Lori, hammers home again that, look, this is the conspiracy angle, and this is what you have to convict on. And this is, this is her role, this, meaning Lori, this was her role in the conspiracy. Obviously, closing arguments are kind of the Cliff Notes version of the case that was just presented, right? That's the point. You kind of just put a bow on it. And I thought it was much more concise in how she delivered that to the jury, kind of lining up again. She had kind of laid out the dots over the last week, but then in her closing arguments, she took all those dots again and really kind of compressed them down and made them, I think, understandable to the jury, kind of reminding them, look, this is kind of what I was laying out, and this is how you should read into what I just presented to you over the last week. I also, want to point out, I think I did earlier too, that what we learned in the last trial from the jury was that they took a lot out of the fact that Lori didn't present a case. Aside from the facts that were presented in court, the last jury in the last case said, look, we found it pretty shocking that she didn't present any sort of defense, right? And so you have to wonder if this jury is thinking the same thing. We have argued that this case, at least our panel did earlier, which I somewhat agree with. This case is the one case where she could potentially, be acquitted on because they don't have as much direct evidence to point her as being the one, maybe the ringleader in all of this. We know from all the other cases that, that this in a roundabout way, she kind of was the ringleader, her and Chad. But yeah,
definitely. And they were 50-50 in that part.
Right.
I mean, they have been convicted in Idaho. It is the same case. The Idaho case is the largest.
Right.
And then you take this Gilbert case, and it's a piece of the pie in here in that case. So in our world, in the overall general topic of this, we know she's a convicted murderer, and that we know the motive now. The jury doesn't necessarily fully understand the motive of this incident on October 2nd, 2019, but all they need to do is answer the question yes or no. Did she do anything that promoted what happened? Did she allow this to happen by her actions, regardless of what she knew in detail? Because, like, we know we haven't read text messages for this trial. We haven't heard phone calls and recordings.
Well, and that was the challenge. We knew there was a lot of overlapping evidence with all these cases kind of intertwined that wasn't going to be admissible, that was kind of left open. But then you also have, Lori, there was also evidence that maybe could have been presented that wasn't. Look, the previous trial, Trina K didn't call all of her witnesses. This case, she didn't call all of the witnesses she planned to. Not that any of that evidence would have mattered anyway. We don't really know, but we do know that there's stuff that wasn't included in this trial that would have alluded to more to the dark and light spirit kind of talk that we heard in these previous cases. But I guess we'll find out if that makes a difference. How much do we read into how quickly they come to a decision? Do they come back? Does the foreman come back tomorrow with questions? If we find out that we get to the lunch break and they haven't made a decision, what do we read into that? Do they take longer than the last jury? So we're not going to have much, obviously, we're not going to have anything going on in court tomorrow for the most part. But it'll be interesting to see if that gives us, again, the litmus test of whether or not the jury is still mulling their decision. Because, I mean, what are we, 3, 4, 5 days almost of testimony? That's it? I mean, we could get a
18
verdict
witnesses
around
in
the
5
same time
days.
that we got opening arguments this time last week.
Yeah, basically taking a week or so. If jury deliberations goes past tomorrow, then you're looking at a possible hung jury, right? If it's lasting a whole day, 8 hours.
That would be my lead, yes. That's how I would read it, right? I think our panel would agree that they're still, that they're debating amongst themselves, again, about whether or not there's enough there for the conspiracy charge. And then we can talk about whether, putting Balance on the stand last was the right decision, whether, whether Detective Hermosillo from yesterday should have been the last witness. I still think very strong witnesses. But then also, ironically, is it the fact that Lori didn't have a defense? Did that help her? Because, again, she fell back into that trap that she did in the last trial with her closing arguments, where it came across as she was testifying. Trina K had several objections like she did in the last closing argument.
Riddled with objections, this closing argument. I mean, it didn't last very long. It got emotional, and it did sound like testimony.
Yeah, and that struck us, too, that she's very emotional and tearing up in this closing argument, but we didn't see that from her in her closing arguments in the Charles Vallow case. So, there'll have plenty to talk about, obviously, as we get closer to this decision. But we're going through the bites here. I'm listening. I would argue this was a better closing argument in this case than previously. But again, with with not having as much directional evidence to tie Lori to this, I think Trina realized, look, I've done all I can here with what I was, given, and the burden of proof and all that she was short and sweet and to the point.
Trina's rebuttal, I felt, was even stronger than the closing argument.
Yes.
The closing argument, you have a lot of information to boil down and condense and break it down in order and whatnot, and you're presenting this PowerPoint presentation basically to sum up all the facts and the evidence to the jury. But the rebuttal, to go after Lori and say, you can cry up here, do whatever you want, but the bottom line is this is not a family tragedy. There was a clear conspiracy. There was an alibi created with the burner phones, the real phones, and she is not afraid of mentioning Melanie Pawlowski. I would love to know what Melanie Pawlowski is thinking right now, because she has been considered a suspect in this investigation, still an open investigation. No charges have been recommended at this point that we know of, and we can check on that right now. We could ask Gilbert PD if they've recommended charges to the county attorney's office, because they never did for her. They only did for Chad Daybell, and the MCAO said, no, we're not going to prosecute. But this looks bad on the part of Brandon's ex-wife as well, and it does make you wonder, as everyone is asking, as Melanie's name is brought up again and again and again, will she be charged in this case?
Yeah, we were surprised when we heard her name brought up by Trina K outside of the jury at that time, that that Melanie is still being investigated in this case. The first time we had heard that, she brought it up again today. we wondered whether were investigators in Gilbert waiting for this trial to play out to see if there was evidence they could use in their investigation. I wonder if there was enough out of this. I mean, there was a lot about phone calls today between Melanie's phone and Lori's phone on October 2nd, even prior to that. Was that Melanie relaying to Lori where Brandon was? Again, they don't have recorded phone calls between these two talking about it. And as far as we know, there's no emails or texts that say, yeah, hey, Lori, here's, Brandon's new address. Maybe investigators have that and we haven't seen it, but the fact that it's still open 6 years later, almost 6 years, 5.5 years later, I'm kind of surprised by that. And I guess we'll wait and see. So is there a sixth trial or whatever? It's hard to tell now.
Oh, man. Let's not talk about any of the trials. But we did get through this one quick. This trial is basically, we are just waiting on a verdict now. Lori, also important to note, objected to the aggravation phase. If she's found guilty in this case, again, she doesn't believe that there should be aggravating factors. She's already serving life in prison for the Idaho convictions. Yeah. So again, stipulating to the aggravators. And so if she's found guilty, she'll have her sentencing for this case, just like she'll have her sentencing for the conspiracy in the murder of Charles Vallow at some point this summer, you can assume. And then after sentencing, she would return to jail, or maybe she would be transitioned to the Department of Corrections in Arizona for a little bit and housed there. And then Idaho will call, for its extradition. State of Idaho will call for extradition, bring her back to Pocatello Women's Correctional Center, and she'll serve this the life's terms for killing J.J. Vallow, Tylee Ryan, and conspiring in Tammy Daybell's murder. So that will happen. That is the inevitable. The question is, how much longer does she stay at the Estrella jail here in Arizona?
Yeah. You wonder how long?
It's all on extradition logistics and all of that. And
yes, and the appeals.
Maricopa County Sheriff's Office and where they can get her back to Idaho. It will happen whether or not she's found guilty in this case. We're just waiting for this case to be finished, and then sentencing will happen.
Do you think, again, victim impact statement, anything like that? We know Brandon had a lot to say on the stand. He's the only surviving victim, so we've heard from I think Tammy Daybell's family in the Idaho trial. So we've heard.
Everyone affected.
Yeah. That'll be interesting. Again, Brandon's had his opportunity to confront Lori. Obviously, she cross-examined, but
if she's found guilty in this case and at sentencing, I would fully expect victim impact statements by Brandon Boudreaux, who gets to not only speak for himself, but he gets to speak for everyone. If he does it and doesn't, she's already convicted at that point. I don't know if it opens the door and he's allowed to talk about JJ. He's allowed to talk about Tylee. He's allowed to talk about Tammy, Charles. I don't know what that victim impact statement will look like, but I think more important, the priority and focus for him, get that off his chest to the person who is right now accused of doing this, innocent until proven guilty. We still do not have a verdict yet, but if that happens, if she's found guilty, there will be a lot to say. All right, so this is the plan. We got 2,000 of you watching. We're about an hour and a half away from our newscast, and we've got to get our on-the-record nightly recap ready for you guys as well. So a lot more talking to do, but the plan is I'm talking to the panel right now on the group chat, and tomorrow morning at 10 a.m. we want to be back here streaming with our verdict watch clock on the screen, so you see how many minutes have elapsed and how long the jury has been deliberating, and we'll be waiting for the news that the verdict is in. And also we will check in to see if that verdict will be read on a 5-minute delay or the 30-minute delay, or will it be live. I don't think it will be live, but it was a 5-minute delay on the last verdict regarding Charles Vallow's murder. But we'll be streaming, we'll be talking, we'll be, running old clips. We'll really be just here to talk with you all and answer questions until we get word that there is a verdict. We'll take some breaks, but we will be streaming, that is for sure. So you do want to be here. Make sure that you subscribe to our notifications for our live streams. We'll most likely be on Fox 10 Talks as well, talking about the case with our colleagues, because there's been a lot of interest across the newsroom and obviously in the public. So that is it. Basically, Any other questions we have? Kathleen Allen asked, will the jury be back today? No. Jury not back today. Jury back tomorrow, 10 a.m. They left a long time ago. They made it very clear. And this was just like the last trial where 15 minutes after getting the case, they said, all right, time to go home. And, you know, it's been a long week, so you can understand that. We also covered today Lori's motions that were denied to have basically accusing Judge Green and Judge Boreski, two judges of violations, of wronging her, of not treating her fairly. We've posted those. I've posted those on my X account, my Facebook account. It is hard to read, so try and use some sort of filter and try to darken it and sharpen it to read what she said, but basically accused, Judge Boreski of treating her badly, putting fear in her, following that moment, that huge exchange, kicking her out of the courtroom for a little bit last Friday. All right. Have we missed anything? I think we're good.
I think
it's a waiting game.
For today, I think we're good, yes.
Hurry up and wait. So the jury of 7 women, 5 men decide the fate of Lori Daybell. We know her fate overall, but you know what I mean. Yeah. And it's also important to note that one of the jurors that is still in this final jury, she was a foreperson in a trial a decade ago. It was a civil trial, but still, maybe she is a calming mind. Maybe she gives him peace of mind. Maybe she's not even the foreperson at all. It'll be interesting to see what happens after the verdict when the jury comes out and our crews are just waiting to talk.
Yes.
So
waiting for the bus to. Yeah. That was the thing, right? They had to get on the bus to take them back to their vehicles.
Maybe they have an alternate route. Maybe our friend Vincent is planning an alternate route for them if they don't want to talk. All right, you guys, thank you for watching. We'll see you in a little bit. We'll be back on coverage of the Doomsday Murder Trial. See ya.